So yeah, the background of the class, we've been given this class for a long time, probably 6 years or more, and through the Contra Costa County Law Library. And we've met a lot of interesting folks. And it allowed us time to augment our material. So as time goes on in our practice, we go, oh, we can add that to it. We can add this to it. We can add the other to it. We should be done around 12:30 or earlier, depending on how much enthusiasm Tamara has here at Cal Legal Dogs.
It's always my fault. Always my fault.
Oh,
Sorry,
I'm
guys.
I'm just giving you an opportunity to express yourself. I don't want to limit your creativity, but I do think we ought to get started. And if other
Go
people
for it.
pop
Okay.
in, that's fine. But so there's somebody. Uh, what we're doing, this is court accounting. This is unique. It's also called fiduciary accounting, where you're acting on someone else's behalf. You've got someone else's money. It is nationwide, although California is particular, and that's all we cover here in California. If you ever see any information on fiduciary accounting coming from another state, you can ignore it because it's not going to be helpful in California. Uh, so what the fiduciary accounting is required for probates and for guardianships and conservatorships. It's not required for trusts, although if trusts get into litigation or there's a court request for accounting, then this system will be in effect. Um, kind of an overview of what we're going to do is we are going to be teaching the judicial council forms, which is kind of like the judicial councils, like the board of directors for the California Supreme Court, and they approve all court forms. And although I have examples of spreadsheet accountings, getting an understanding of how it works in the court forms is better for the overall comprehension of what this thing's all about. When you get into the spreadsheets, it's not as detailed, and but it's easier to convert to the spreadsheet method. Um, let's see.
I'm gonna
Go
jump
ahead.
in there a tiny
Sure.
bit and say I believe about the trust. There are four different type of accountings. I will start that the trustee must account every year after the trust becomes irrevocable. And I was just recently, because I do a whole lot of countings, that a even if you have what's called an AB trust, so we always say, I use the AB trust when I'm thinking, what is an AB trust? AB, I use, Rex taught me this, but A is above ground, meaning still alive. B is below ground. I just recently had a trust I had to do where it was an EB trust. My husband passed away. His half became irrevocable, and mom is still alive. But the beneficiaries requested an accounting of mom on the trust. And we went through several laws to make sure. I want to say Gatlin was one of them, and then there was a couple more. But anyway, which states that a beneficiary can request an accounting from a trustee if the trust becomes irrevocable either by death or by incapacity, and or if a trustee is replaced from the original settlers. Beneficiaries can require accounting. And typically your trust will say every year an accounting is due. So there are 4 different type of accountings. There could be a trust accounting, tiny bit different than what we'll teach here. The accounting's the same, going how to put it together is a tiny bit different, is what I mean. There's probate accountings, that's where there's a death. There's a guardianship accounting. That's when you're taking over as taking a guardianship. So that means typically a minor will inherit. A minor cannot inherit. I'm sorry. A minor has assets from usually a parent or somebody who has passed away, and then now they are receiving an inheritance. And then there's a conservatorship accounting, so the guardianship and conservatorship accountings are due first year after appointment. And then after that, typically it's every 2 years, but the court can request, if they feel the first accounting does not look 100% great, not even 100%, it doesn't look fantastic to them, they can require an accounting yearly until they tell you it's done every 2 years. So there are 4 different type of accountings.
And I also wanted to draw the distinction on guardianship and conservatorships. You're taking care of someone else. There's conservatorship and guardian of the person. And if you are appointed as a guardian conservator of the person, you do not have to do accounting because you do not have access to the funds. If you're appointed, as a guardian or conservator of the estate, that triggers the accounting requirement because now you are in charge of the funds.
Correct.
Okay.
Okay, so let's go through the slides. Let's get going. Start moving those slides.
Yeah, let me find is it here? There we are. Okay, so we're taking this material from the book Handbook for Conservators. This is a free book online. It is not a bestseller because it's free. It's from the Judicial Council, and the source when I gotten this a while back is californiacourts.ca.gov. So you can the information that we pulled out of here is on accounting. It also has other training material that is appropriate for conservators, and it is also similarly good for guardians. So the plan here is Tamara and I are team teaching this, so we go back and forth. She will teach the inventory and appraisal section. Then I teach the accounting part. I'm also a CPA in addition to being an attorney. So I'll teach the accounting pages, and then Tamara will come back and teach the petition to the court that you use to request a final accounting to get your accounting and approved, like for a probate where there's a distribution. So let me go back here.
Okay, I'm ready.
Yeah, I'm looking at the what do you call it? Word. Oh, here we go. No. I'm looking for Tamara's picture on my screen. I got a bunch, but I don't see Tamara's. Or did you
need to share my screen first.
Okay.
I mean,
I don't see you either, Tamara.
Okay. I'm here.
I got you. Your video's on and your audio's on?
No, I turned my video off.
That might be, okay, now I can see you. Now I can function. Okay. Hold still here. Okay, so I'm making you host, camera. You can run your screen. Um, and you're in charge. We're at different locations. That's what we're doing at the moment. And let's see.
Okay, can everyone see my screen?
Yes.
Yes?
Yes.
Okay. Okay, so I'm going to start off with the inventory and appraisal. So the reason why I'm starting off on the inventory and appraisal is when you're going to start an accounting of any kind, except for a trust accounting, you will need to start with the inventory and appraisal. So this is the reason why we're going through the inventory and appraisal. If you are in a probate, guardianship, conservatorships, and the inventory and appraisal has not been completed, and you want to start your accounting, you cannot do so without starting the inventory and appraisal first. It's very important that your inventory and appraisal information carries over to the accounting so that you can start and do your accounting. So, the inventory and appraisal is done on the what's called I'm going to do these upper form sections or sections that state the form numbers. DE just means decedent's estate. That's typically for probate. That will be for conservatorships. Sorry, it will not. It's only decedent's estate. So they refer to that in probate, DE 160. Or if it's a guardianship in a conservatorship account, then it will say GC 040, guardianship conservatorship. So this is the form referred to for the inventory and appraisal. Typically, these forms are blank, so I'm going to go through how you would complete it. If you were a pro per, our example is from many years ago, so it was an example from the court Contra Costa, so we just continue to use it. But the example I have is as if it is completed by a law firm. So I'm going to show you what you would put if you were a pro per. So the first line would be your name. You will not have a state bar number, so it will just be your name and your address, your telephone number. Fax is optional. I typically don't put a fax number in here because most people don't have fax numbers anymore. Email address. This is typically important if the court, for some reason, wanted to send you back a copy of your document or communicate with you. Typically, they'll communicate with this email address. Although it does state it's optional, I always include it. Attorney for, this is if you did have an attorney, but even if you don't, you still complete it. You would put your name and then what you are or your title typically. So in this case, this lawyer is representing David Lowry, who is the conservator. You would typically put your name, comma, pro per, PRO space PER. It means you are not represented by counsel, so you are completing this on your own. As you move down, you will select the court. So you need to know your court name. In this case, we're using, the example uses orange and provides the address of the court and the actual branch. For Contra Costa, it's Wakefield Taylor. For Los Angeles, it's Stanley Mosque. It could be, so putting the courthouse name. Typically, if you don't know like the branch of the courthouse where probate is held, I will just put probate department. So you can put that also if you don't know the court name. So now going down, we are going to go through how to fill out this section, which states estate of. It doesn't necessarily mean estate, but technically it will. So in this case, our example is Jeannie, and she is a conservatee. You would put the name of the decedent. You would mark this box, or it could be the name of the minor if it is a guardianship. So depending upon what your case is the box you would mark down here. You would not mark two boxes ever. Either they're a decedent, meaning passed away, again, conservatorship, or a minor. You again would not be completing this if you were a trustee. So moving down to the section that says inventory and appraisal. So you can mark partial. I'll give you a few examples on why if you would only mark it a partial. Sometimes specifically more so in law firms, but it could be if it was a conservatorship, if there is a house or real property you wish to sell, and you know the property address and you want to hurry up and get it over to the probate referee, who takes quite a bit of time typically to value property, I would do a partial. I would mark it number one, and I would maybe only include the real property. That would mean, though, that you still must do a second one so that you're marking a final to tell the court this is all the assets of the estate. But that is the reason why, or when you would mark partial. And or again, if it is, and we'll go through, there's many examples, like say for instance, this decedent passed away in 2012, you have limited authority, so you need court approval for a house sale on a probate. Then you would have to get a new appraisal done, marking a different box that would say reappraisal for sale, and then the probate referee would value the property as of today's date or when they receive it. A corrected one would be only if you have already turned in an inventory and appraisal and something you stated is wrong in that inventory and appraisal. I see this often because when I review trusts for people, accountings for people, the first thing I ask for is their inventory and appraisal. A lot of times the first thing I look at is what assets are they reporting at the beginning. Then I compare that with bank statements that I have for the accounting. And a lot of times I see numbers are not correct. So they must file a corrected one before I can complete the accounting. Then you have your final, which is stating everything, every asset that is owned by the decedent at time of death or is owned by the conservatee at the time of appointment or owned by the minor at the time of appointment, will go on this form. Now, keep in mind that does not mean, say, for instance, a minor, you're doing a minor account and they haven't inherited from the parent yet, but the parents passed away, so you're waiting for that to take place. Then you would not include the information as they haven't received the asset at the time of your appointment. I already went through a reappraisal for sale. A supplemental can kind of be, kind of like a corrected. They're used kind of the same. A supplemental would be that, say for instance, you already reported a stock portfolio annuity account and it's different, or somehow you could do a supplemental and change that. I don't use the property tax certificate. I don't think ever have in all the years I've done these. I just don't use this box, but that is the difference on if what you're marking in box here. I'm going to switch over to the right side. You will include the case number. And this box is very important, and you have to be very careful on the date that you are putting here. So I'm going to go through this. So it is the date of death of the decedent. So if this was marked and this box for decedent was marked, you would include their date of death, the exact day of death, not day after, not day before, not day they got sick, not day they went in the hospital, the date of death only. That's very important because the date of death is when you're going to start your accounting. For a conservatorship or a minor account, or inventory and appraisal, you will put the date of appointment. That is typically the date that the order from the judge was signed and or the hearing date. So when you completed application for a conservatorship or an application for a guardianship, the first time you went to court, it might have been continued. You would not put that date. You would put the date the actual hearing happened and the judge ordered you, either the conservator or the guardian. So the date's really important because it carries forward. So first thing I'm doing when I review accountings for law firms or preparers is I'm looking at specific things. I'm going to this date. Sometimes I'll ask for a copy of the order. I want to see that they have this date proper, so that when I complete an accounting, because I would hate to complete an accounting for somebody and then they turn it in and then it gets kicked back. You have the wrong start date. It's happened many times, and I typically correct them easily once they provide the court provides a different date, and or I myself, when I'm doing accountings, can look up the case and really find out what the date of appointment was to make sure it's accurate. So make sure this date is not the date you receive your letters, which is the D150 or the GC050. It is the date of appointment or the date the order is signed by the judge. Is there any questions on this first half? Oh, good. Yay. Okay, getting down to the appraisal portion. You have two different appraisal portions. You have attachment 1, very important. Attachment 1 is valued by either the administrator, the personal representative that would reflect a decedent's estate. It is the guardian, which would reflect the minor's estate, and or the conservator for a conservatee. So if you're doing your inventory and appraisal, this is everything that would be valued by you. In attachment 1, realize attachment 1 is cash and cash only. So I'm going to move to the attachment 1. And here is what an attachment 1 will look like. It is the next form in line to the DE 160. So it will state it's a DE 161 and or the GC 041 instead of the GC 040. This will be blank, so you will need to put the state of, which means whatever name that you indicated on this line will be carried forward to this line. You will also put the case number. This attachment, it will only say on your form attachment number. You need to indicate it's attachment 1 if that's what you're doing. Now on attachment 1, I'm going to show you examples of what cash assets that you may have. Likely you will not have all of these. Likely you may only have one. You may have two. We'll go through the different examples, but do not think you must have all of these because you likely will not. So in like a decedent's estate, you might find cash at the residence of the decedent. If that is the case, you would indicate there was cash. A lot of times for a conservatorship, typically a conservatorship is an older person, but sometimes it could be a younger person that has disabilities and they need assistance with their estate. They may have cash on them. If they do, you must indicate how much cash they do have on them. I do not indicate the place, especially for a conservatives resident, because of the fact that this is public record, anybody can get it. I just don't want people to know that my conservatee who is vulnerable has cash. It's just not necessary. So I will just put cash and then the amount of the cash. You must put the total. The second example is a checking account. Please always know you will only include the last 4 or 5 digits. The sample includes 5 digits. I only include 4. Typically, it's the last 4 digits of the account number. Again, this is public information. I don't think it's necessary, and the courts have other ways of finding out information about the account. They don't want that, and you will get a stern hand smack if you turn in an inventory and appraisal that has the entire account number of the conservatee or a minor, because there's too much fraud and stuff going on out there. So please be careful with that, okay? I also do not indicate the address of the branch. I will typically put just Wells Fargo, Travis Credit Union, whatever the bank name is. I don't indicate the bank address. It's not really important that I know of. I've never done it. So I will just put where, Bank of America, whatever. I will put the amount. It is very important that this amount you see right here is the amount as of the date of appointment. It used to be a few years ago that it was very difficult when you looked at a bank statement to see what the actual balance was on a specific date. Now the bank statements are nice. Typically, you'll see at the bottom or somewhere on one of the last pages or somewhere you will find the actual balance every single day. You have to make sure that you indicate the balance on the day of that appointment. So I'm going to go back and switch screens so it's on this specific date. Do not put, like, bank statements run usually 30 days or a month. Don't put the beginning balance. So you were appointed, let's say March 8th. Don't put the balance it was on March 1st. That's not an accurate number. That is the number one thing that when I'm starting accountings, I will bounce back and say your inventory and appraisal is incorrect. Meaning I will look at the bank statement and see that the balance they have indicated on the inventory and appraisal is not the balance that I see on the date of appointment. So if that's the case, the accounting gets stalled because you have to first correct this inventory and appraisal, turn it into the court, and then I can begin starting again with the proper balance as my beginning balance. So be careful on this number right here. It's one of the number one things that people come to me and say, I cannot get my accounting to balance, or I don't know what's wrong, or things like that. And it's the number one thing of when people turn in accountings, that the examiners will put an examiner note that states either the inventory and appraisal doesn't match the accounting, or it doesn't look like it's the proper number. So be careful on this number right here. Now, another example would be a savings account. You cannot lump these together. Please be sure that if it's a different account, whether it could be a second checking account, you must list them separately and indicate the account numbers. Again, I just use the bank name. I do not use the address. You could have a certificate of deposit. You would need to state the bank name. I don't include all of this information in here. Typically, I'll just put certificate of deposit, put the account number, and not the full account number again, and where it's at, and then find out amount. This is typically rare, but I have seen them. Now, in our example, you do not see this often anymore, but as part of our example would be an uncashed check. So when you become appointed as the administrator, or that's a decedent's estate, or a conservator or a guardian, you won't see this in guardians. So in a conservatorship, it used to be that the conservatee would receive their pension in the mail via a check, and say it's sitting on the table or part of a big stack of mail that hasn't been opened. You discover it needs to be deposited but hasn't yet. You will indicate there's an uncashed check. Nowadays, everything is direct deposit, so you don't see these. In fact, I don't see them anymore ever really, but you would indicate there's an uncashed check, meaning the amount of money was prior to your appointment, but because it wasn't cashed or deposited, you would need to indicate it here. Another example would be an uncashed Social Security check. I don't see these anymore either. Social Security does direct deposits now, so you don't see these anymore, but say you did. One thing you could see, though, is an uncashed dividend check. Typically, people do a reinvestment of dividends. So the dividend check is not paid out, but when people get to become a certain age, they must take dividend distributions or distributions from the account. So you may receive a check in the mail that you need to deposit. It is your responsibility as the administrator or the conservator to properly maintain the assets and properly account, so the court knows what type of estate. The beneficiaries of the person also know exactly what you're dealing with. They're able to watch and monitor things. You must be very open. Okay, so now that you have all of your totals that you've put here, at the bottom of the page, you will always put, I typically put it up here about where this is, I will put a total attachment 1 assets. Now, in this case, they total the 57,844.59. I take this number and I go back to the front page and I enter this number here. See, it says attachment 1. This number is exactly the same number I showed you as the total down here. So you transfer this information forward. Now, there could be many other things that you have on here. Again, you may have just a checking account. You may have a checking and savings account. If it's a decedent's estate, you may have nothing, to where sometimes I'll indicate that cash I'll write the word cash and then I'll write 0 here. And then I put 0 down here and transfer the 0 forward. It doesn't mean you'll have money to indicate here. Don't be alarmed. If you don't have it, you don't have it. Sometimes it happens that way, many times actually. So sometimes my attachment 1 will just have the words cash and say 0, and that's the only thing on the form. That's okay. With a minor or a guardianship account, typically that minor does not have any assets when you get appointed. Again, the only usual reason for a guardianship, or most common reason for a guardianship, is they are going to inherit from somebody and they cannot inherit until they're 18. So at the time the inventory and appraisal could say 0, they have no assets, but they will get assets during the whole guardianship case. So that will be indicated on your accounting, but would not be indicated on the inventory and appraisal. So I've completed attachment 1. Are there any questions to attachment 1 assets?
I have a question.
Me
Sure.
too. Okay.
Okay. What if you have unclaimed, you have dividends, but they're all in unclaimed property for the state of California? Do you still list them there?
Yes, ma'am, you do. You would state unclaimed property, state of California, and then the value of that. And those are very difficult and very time consuming. So if you haven't started, you should really start right away, because they take weeks and months and months and a whole lot of paperwork.
Okay, I have a question.
Go for it.
When I took over appointment for my mother's estate, I combined her checking and her savings account and made an estate account. Was that not okay?
That's proper, but realize this. So for a probate, I'm going to switch back my forms. For a probate, this date of death is how you will record. So it doesn't matter what you did after the date of death. You will still provide on the inventory and appraisal her checking and savings account as they were
Okay, prior to
on date of death.
Okay.
So
Okay.
you're transferring to an estate account will only be recorded on the accounting portion. I don't believe Rex really goes into it, but it's what I would record as a change in form on the end of the accounting. And what that means is you just changed it from a checking or savings account to one estate account, and that'll be totally different form. But this is date of death.
Okay.
So again, it's a stop right there. Just date of death, stop. Not what you did the next day, not what you did a week later or a month later. Date of death. Just
Okay.
all that's
So
all you have to think about.
The change in form of assets is Schedule F.
Okay.
Okay, yeah, mine's G or something else, but okay. Well, yeah, Rex can get into that when he goes through the accounting. We won't worry about that. We're only on the inventory and appraisal right now.
Okay, this is only date of death. Just put the amount.
Date of death, hun.
Okay, thank you.
You're welcome. Any other questions? Okay, I'm gonna speed back now. Now that we're on attachment 2, right? So attachment 2 is only for a probate referee. Okay, so a lot of people ask me this. Well, how do I know if I have a probate referee, or how do I know who that probate referee is? A probate referee is given to you by the court. It is appointed by the judge. You do not go out and find your own probate referee. You don't use somebody that's different than the court-appointed probate referee. You will look at, if it's a decedent's estate, it will be on the DE 140, which is the order. It's at the very bottom, and it will be a checkbox. In fact, it's the last thing on the DE 140 before the date and signature of the judge. It will be a box, and the court will indicate the name of the probate referee. If by chance you turned in a probate and you didn't indicate there were any real property assets, and you only listed cash on your DE 111, which is the petition, the judge did not know that you needed a probate referee, so maybe they didn't give you one. That happens often, more than I like to see, but it does happen. And in that case, you have to completely file different court forms that request the judge to issue you a probate referee. It will cost you to get a probate referee if one was not appointed to you at the very beginning, and it takes some time. So if you do notice you haven't done your inventory and appraisal, but you now know you have assets that need to be valued by a probate referee, you were never assigned a probate referee, you have to complete forms. And depending on the county, I do a lot of down south probate work, and depending on the county, every county can be different. They may have their own local court rules, local court forms to request a probate referee, and or it would then in other cases just be some type of declaration that you need a probate referee appointed. It would be ex parte typically, which means you're asking the judge to appoint a probate referee without an actual hearing. So again, if you do not have the probate referee assigned to you, you need to obtain that first. But the probate referee values only assets on attachment 2. We will go through what those assets are, or examples of what those assets are. So again, same form as your cash attachment 1. Again, same exact form number, but instead of attachment 1, you would indicate attachment 2. Okay, here are examples that the probate referee must value. We have real property in this case. So real property, I typically give the probate referee as much information as I possibly know or can, because I have the ability to run deeds. I'm able to give a legal description and put in a lot of information. Some people don't have that, so you may only put real property in the city, whatever city, and the county, state of California, commonly known as. That might be all that you put on here. I'm going to go through a couple things, which is a little bit different, but I add, which is very helpful for the probate referees, whether this decedent, this conservator, a minor wouldn't have this, but whether they own 100% interest in the real property, are they only 50% interest in the real property? Are they only 25% interest owners of the property? Maybe they're on title with several of their brothers and sisters, or, I don't know, neighbors, friends, whatever it is. So I indicate the percentage of ownership of the real property. That's very helpful for the probate referee, and it's very helpful because if you don't state anything like the sample does, and the probate referee values the property as if Jeannie owns 100% because they don't know otherwise, and say they only owe 50%, well, that can't happen. You would have to get another corrected inventory and appraisal that says, oh no, she only owns half and I'm only responsible for her half ownership. So be very careful. And I like to indicate what is the percentage of ownership. Another thing about this that's very common and very helpful. Let's say which happens a lot of times in decedent's estates. But let's say the home decedent, prior to the passing, they went into a nursing home or something of that nature, and squatters got in, very common, to the property and completely destroyed the inside of the house. Now, I have never heard of a property where squatters get in and take very good care of any property. Never has happened. Never. They absolutely trash the inside of the property. Well, in that case, I typically like to tell the probate referee the problems, or that the value of the property is not at its best, or should not be valued at its best, because of these problems. Like if there's holes in the walls, if there's pipes missing, if there's the roof is barely hanging on, if there's so many different things I could state that happen with real property. So I typically will indicate that for the probate referee, because a probate referee only really does a drive-by. They never have gone inside the house. I want them to really value it at its full value, because there's a few things you say, well, why do I care? Well, let me tell you, or give you another little scenario. A decedent's estate, you have maybe 4 beneficiaries. They don't live here. They could live in another state. So they're looking at this and going, oh my gosh, the house is valued at $1 million. We're going to split $1 million by 4, right? And that's going to be our inheritance. Well, in the probate, you go to sell the house, or the administrator does, and they only get $500,000 for the house because it's completely trashed. Well, I guarantee you those beneficiaries are going to be hiring attorneys, and they're going to try and fight how the probate referee valued it at $1 million, and you could only sell it for 500. And it's because you originally did not tell the probate referee that the entire inside of the house needs to be gutted, or things of that nature. So I really, really tried to be very transparent, even in the inventory and appraisal. So if there is something, or the house just has been ransacked, or a whole lot of damage has been done. Imagine, like, for instance, in Florida, where the hurricanes went through, right? Destroyed inside of many houses. But I never indicated that to the probate referee. I just put the property address, and they go, oh, okay, the house is worth this. They don't realize all the walls have to be ripped out, and so many other things, floorings and all of that. It's really nice for you to indicate to the probate referee. Now, I'm not talking every little tiny minor thing. The dishwasher doesn't work. Okay, that makes no difference whatsoever. Or that the refrigerator's gone, or, those are not bad things. I'm talking, there's walls missing. Squatters have removed the copper pipes inside the walls. So the walls have to be taken down and completely redone, with piping redone, or there's holes in the flooring, or the entire roof is just awful. Things of that nature I indicate, not smaller items. Okay, so in this case, our sample, this conservatee also has a vacation home in a different place. indicate it. Again, use the same type of care and information. Do they own 100% of this vacation home or a different percentage? Is the vacation home in pretty great shape, or is it completely dilapidated? Again, if I'm if I'm a Contra Costa Contra Costa probate referee, and you say there's a vacation home in Palm Springs, that probate referee isn't driving to Palm Springs to see the house. They're going to do online searches and try and see what the property looks like and things of that nature, but they're only looking at a picture. So was the picture taken many years ago? Was it taken recently? So give information if there's anything that, let's say, decreases or increases the home. Like, for instance, there is a ADU unit that has been approved by the county, blah, 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 but the home does not state that in its legal description. Well, that would increase value. So I like to put that type of information for the probate referee. Household furniture and furnishings. This could be a wide range of things. Typically, the probate referees do not give a very high value to furniture and fixtures and furniture. Typically 1,000, 1,500. It's just a very small amount. If you have something like a grand piano or an antique armoire or china cabinet or paintings that have value, that's not household furniture and furnishings. Those list separately. So do not lump those or think when you've said that that's, you're including that. A lot of people don't put the household furniture and furnishings because most of the time, especially for a decedent's estate, they've already come in and donated them or taken them to the garbage or had them removed or things of that nature. So this is really not a very important thing. It covers a wide range of items. A mattress, a bed that cannot be resold, sofas that unless they're in great shape, it's hard to resell them. So keep in mind that your household furniture and furnishings have very little value. Typically, again, I see about 1,000, 1,500 at most. They will give for all of the furniture and furnishings inside the house. But then again, to me, remember that means if you've indicated that beneficiaries are expecting you to sell that furniture and they will like to see $1,500 worth of cash come in for that. So say you did a garage sale or an estate sale and you can only sell it or get maybe $100 and the probate referee valued it at $1,500, you might have some upset beneficiaries. But again, you include it and the probate referee can value. Shares in a mutual fund. This gets a little bit tricky, especially for people who are pro-per that need to read and go through the annuity statements or mutual fund statements that especially because the mutual fund statements and all of that are difficult to read. And somebody has their mic on, so I can hear. There you go.
Who receives mail?
No, I still hear somebody's mic on. Anyway, it's a mutual fund account that you need to indicate how many shares.
Excuse me, Terry, could you mute your mic, please?
So how many shares do you have? Sometimes it's very difficult to determine, but you have to look at the statements and you have to list each share separately. So make sure if the other thing I like to do is most of the time on your investment fund accounts, they will give you an abbreviation of a stock, Apple, Microsoft, whatever. I usually give the code or the abbreviation for that stock to the probate referee. Do not, like, say you have a statement that has let's say 100 different stocks that they own. Don't think you can lump them together. No, it's a pain in the butt, but you have to list each one separately. Sometimes if there's many, I provide the whole statement to the probate referee and say, here you go. It was difficult. You still have to list them separately, but it helps them give date of death value. Remember, they have to go back and figure out what that stock was worth on date of death. So if you're doing your inventory and appraisal, let me just give you a sample. So a decedent passes away today. You wait a couple of weeks because you're dealing with funerals and stuff like that. And so maybe you wait a couple months. Then you file for a probate. When you file for a probate, your hearing isn't for 3 or 4 months, right? Then you got to wait to get appointed. Maybe your case is continued. Then you have to wait for letters. Like, you have to wait all of this time. So by the time you're giving this information to the probate referee, it could be a year later. So the probate referee also has to figure out what was that stock worth on the date of death. So they have to go back in time and figure it out. So they need as much information as you can possibly give them. U.S. savings bonds. I had one recently that the decedent had 65 savings bonds, and you have to give the value of each bond and the date the bond was issued. That is very difficult to come across when you have a decedent's estate. Somebody comes in, they only see the savings bond. It's difficult to tell their series numbers. It's hard. With that, I did list every single savings bond separately, but I also provided the probate referee copies or pictures of the each in savings bond so they could gather information. I later had to work with the probate referee's office and go through, and we went round and round and round trying to figure out value and figure out things. So that's a possibility also, that the probate referee calls you and says, or emails you and says, I need help with this. So don't worry if that happens. You just try and do what you can, even if you don't fully understand the question they're asking. Okay, another example is a diamond wedding ring and 2 carat. A lot of people used to ask, why is this important? Realize, especially if it's a decedent's estate, but in our sample, it's a conservatorship estate. This goes to all of the beneficiaries of the conservatee and all of their family. So say, for instance, you listed a 1 carat diamond ring, and one of the beneficiaries knows that, say this is mom, dad gave her a 5 carat one on her anniversary. First thing you're going to hear is, hold on, wait, what? 1 carat? Wait, no, where's the bigger one? And things like that. I always like to state what it is. Now, difficulty I have, I'm sure others people have also, I have a difficulty if I looked at a ring, I couldn't tell you what size it is, because that's just not an important thing to me and never has been. So Like, I don't know if I could tell a 2 from a 3 or a 3 from a 4, or it looks big. I don't even know. Maybe a picture of it I would include. That would be a difficult one for me to put, but it's important you list everything, because then you don't have beneficiaries asking questions, and they'll want to know at the very end, at the time the conservatee passes away or whatever, what happened to it. They will be looking to find it, see it, whatever it is. And again, you may have many other examples. You may have paintings that are worth something. You could have, remember, a coin collection, even though to you that might seem like it's cash. Typically, coin collections are valued by the probate referee. You would put in, because most of the time coin collections involve coins that have values that go up or down depending on the time, depending what coin it is, depending what year that coin is, depending on where you got it, where it was found, whatever. It is valued by the probate referee. Now, that doesn't mean, let me use this, that you go into a decedent's home, and I'm using the example of my father, and they have coffee containers that have cash that I'm talking quarters, nickels, dimes, pennies, or silver dollars or whatever that they've just thrown in this coffee can. That is not something that goes to the probate referee to value. That's for you to value. And I myself would not sit and count every penny, every nickel, every dime. I wouldn't take it to one of those coin machines either, because they charge an amount for you to turn that in. I would probably just do a guess. I would probably say something like full coffee can that's 8 ounces full of pennies. And that might be something I would say. But there are many other different things that you could see on an attachment to a vehicle. If the conservatee or the decedent owned a vehicle, you would need to indicate the year, the make, the model, and the mileage of the vehicle. The other thing I also do is indicate the condition of that vehicle, whether it's running, whether it's not running, whether it's missing an engine, whether it has no brakes, whether it has a huge oil leak, if that's what's told to me. Things of that nature, I will always indicate on the inventory and appraisal, so when it's valued by the probate referee, it has a close value. Again, many other examples. You may not have all of these examples. You may just have one property. You may have nothing on attachment to. Say they didn't own a home. Say they didn't own a vehicle. Then in that case, again, I would put non-cash assets, and I'm going to put 0. I'm going to value it because there's nothing to send to a probate referee. So these are only samples. You write in whatever pertains to your case. At the bottom, I will, and typically not at the bottom, I will usually put it about right here. I will put total non-cash or total attachment to, and then I will leave it blank for the probate referee to value. Again, you will notice you have not indicated any values along this side. When you send it to the probate referee, they will fill in these values and they will return it to you. What they will also do, which I'm going to switch screens, they will come back here and they will put the total right here, because it's attachment 2, and they will take this total and their total, and they will typically do a full total of all assets combined right here. They will also sign page 2 of your inventory and appraisal form. So this is page 2. They will come here, they will tell the court how much they're billing for that inventory and appraisal. They will indicate if they had any expenses, meaning mileage, tolls, if they had to pay for any type of research materials, anything like that, they will indicate that here. They will put a total, they will date, they will print their name, and they will sign it, and they will return the inventory and appraisal to you. Are there any questions on attachment 2 assets?
Yeah, I had a question. I sent my inventory and appraisal off, and I valued the furniture like at $350, but it's like was really old, so I don't even know if we can get that, for that. So I'm wondering, is there like we might donate it, but is there a way to like on the final one, can I change it?
Okay, so again, you're not allowed to put a value there. So likely if
I did actually.
Yeah, likely if it did go to the probate referee, they're either going to cross out what you put and they're going to put their own value, or they're going to white it out or return it back to you and say they can't do anything with it because you've put in value. Give them a blank form. If they cross it out and put their value, that's perfectly fine. You can turn it in, but they likely would make a change. Or if they allow the value you've given, then that's fine. Then they would keep it and put it in the totals. Even if you can't sell it for that later, you can explain that later on in your accounting, something so small as that.
Okay. And then same with like the description, like about the house, because I sent it to them I didn't do the description like you said with all the, like, say it needed to be updated because she didn't do any like remodeling since 1963. So there was never like improvements done or things of that nature. So I didn't put that in the description either, but I was going to put in some money to have it like painted or fix it up a little bit, but not sell it kind of as is in a way.
Right. And all that you will record in your accounting. So what you would do is when you're recording expenses for like painting and stuff, you would indicating upgrading the house for sale or something like that.
Okay, on those different schedule things that Rex is going to tell us about.
That's correct.
Okay, thank you.
Any other questions on attachment 2? Okay, I'm gonna move on. So completing the rest of the form, I'm gonna go down. So the rest of the form, so you need to complete number 3. Now, number 3 asks the question, are you indicating all of the assets, which means you mark this final, you would be all of the assets? Or are you only turning in a portion? Again, remember when I was talking about the reappraisal for sale or the partial, that would not be all. You would mark this portion box. So you're going to have to mark one of 2 boxes. Either it's all of the assets or only a portion of the assets. Now, if it's a partial, you would mark it a portion, and then the next one you do would likely be a final, then you would mark them all. So it's dependent on what you're actually turning in. We're going to go down to number 4. So again, if this was, let's say, a minor's estate and I didn't have any assets, or the minor didn't own any assets, you would mark this box right here that says no probate referee is required. Or say this conservatee did not have a house, did not have any attachment to property, all they had was cash, then again, you would mark number 4 as no probate referee required. Or, so one of the 2 of these boxes must be marked. or you do have attachment to assets, or the court has provided you with a probate referee. You will mark this box and you will write the date of the order. So again, typically, if this is not the date of death because you don't have a decedent, you have a conservatorship, this date and this date are likely going to be the same date, unless, again, when you got your original order, you did not ask for a probate referee but needed one. So later you had to go back and ask for a probate referee. You would put the date the judge signed and provided you the probate referee's information. Going down to number 5. Number 5 has to do with property taxes. There are 2 boxes. One, A or B must be marked. Here is the difference between A and B. A is there was no real property, and I'm talking real property is a house or vacation home, real property, land, vacant, even if it's vacant land, real property, right? So either there was no real property in California at the time of death or the time of conservatorship, or so you would mark this box, or there was real property, and marking this box tells the court that you have turned into the county assessor a change of ownership statement. See the words? So in our sample where I have a vacation home, oh, wrong sample, attachment 2, real property, the house of the conservatee, and a vacation home, I would record with the county assessor a change of ownership in both counties. So when it asks down here about the property tax, you would mark this box. Again, this tells the court that you have notified the county assessor that the decedent has now passed away and you are responsible for property taxes and whatever, any other communication, or a conservatorship stating that the conservatee, you are responsible for making sure property taxes, etc., are paid on this. So you have notified the county recorder and or assessor that the property is no longer being managed by its original owner. Then down here, you are going to continue to complete the form. So again, you're filling this out as a pro per. It needs to be, it's very important, and watch the sample, that you do not sign or complete a date or signature until after it's returned to you by the probate referee. Do not sign it prior to sending it to the probate referee. You want to wait till it's completed and returned to you by the probate referee. And then you'll come back through, you'll date it, you'll indicate your name, you'll sign it, and you'll continue on the rest of the form. Okay, so it says statement about your bond. There are 2 different ways, maybe 3 different ways in an estate. Either bond is waived, meaning it's a decedent's estate or a conservatorship account and the court has waived bond. You will know that, promise me. It's not, you won't have to guess it. Or you had to file a bond. So the court ordered a $20,000. That's the minimum bond in California. So the court orders a $20,000 bond. You had to file that bond in order to get your letters for the conservatorship or the guardianship account or become an administrator. So you would mark a bond was required and I would indicate here 20,000. Yesterday I got a pretty high one. I was like, wow. The court required $1 million bond. A lot of people won't qualify for $1 million bond. So you need to understand that if you're doing a probate, say for instance, if you're doing a probate and you cannot get family members, potential beneficiaries, potential heirs, to sign off on a waiver of bond, and the court orders $1 million bond, but you cannot qualify for $1 million bond, you would either need to change your petition and go the limited authority route that could, decrease the bond, or if it's all cash, it goes into a blocked account or something of that to try and figure out how to lower a bond. And then if that wouldn't work, somebody else would possibly have to apply who could qualify for a bond in that amount. So you would indicate your bond amount and you indicate whether it's sufficient or insufficient. And I'm going to ask for some feedback, somebody to answer this, but after I ask the question. So let's say I have 0 attachment to assets, just for example, and my cash assets are 57,844.59. The court, when I obtained letters, it had me obtain a minimum bond of $20,000. So I marked this box and said bond $20,000. Will I then be able to mark the box sufficient or insufficient when my cash is showing 57,844.59? Just a guess. Anyone take one?
Insufficient.
Insufficient.
Awesome. See, I got you guys awake now. So that absolutely would be insufficient. That doesn't mean you're wrong or did something bad or gonna get a hand spanking, nothing like that. It just means that you're telling everybody honestly that you realize your $20,000 bond is not sufficient for the amount of cash that you are controlling. And let me give you a little bit different in why it's important. So if you're able to manage $57,000 of cash and your bond is only 20, say for instance, and I know for a lot of us will go, well, there would be no reason that would happen. Happens every single day. Unbelievable. But this $57,000 disappears. We don't know where it went. I don't know. She had it there, but now it's gone. I don't know. I don't know where it went. Guess what the next thing that's going to happen? The court is going to go back, attack the bond, file a claim against this bond and get back at least $20,000 because that's your bond amount. So typically the court wants to make sure that your bond covers every bit of cash that you you have control of, so that if any or all of the cash disappears, the court can get back the money and put it for the beneficiaries. Again, you don't know how many times cash disappears. Nobody knows what happened to it. It's gone. And in a lot of cases, it cannot be retrieved. You can't get back something you spent, like it's gone. So the court typically will make sure that your bond and your cash, the bond is high enough for this cash. In some cases, the court may call back and say, I need you to increase your bond. I need you to go now increase this bond from 20 to at least 60 so that I make sure that there's plenty, the bond covers all of the cash in case it should disappear. So that's the significance of that. Another example would be, and this would typically is used for guardianship accounts, is you put all of the cash. So say the minor inherited money from their parents, and they inherited $57,000 in cash, right? So what you would do is put it in a blocked account, meaning you can't touch the cash, and neither can the minor till they're 18. And if that is the case and you put the money in a blocked account, you don't have to have a bond, because you can't touch this money without a court order anyway, and no one can touch the money, so it cannot disappear. So a lot of people who may not qualify for a high bond can say, okay, fine, I'll put all of the cash in a blocked account, and then I won't need such a high bond amount.
Can I
Those
ask
are
a
little.
question?
Yes, son.
Okay, so my child is a minor and he inherited funds from a relative.
Uh-huh.
And so I've already gone through all of this. I've filed the inventory. I have the bond. But my question is, because the funds are invested, the value is going to exceed the bond very shortly.
Mhm.
And
That's a
so
great thing, though, hun.
it is a good thing. So I already know that I'm going to need to re-up, increase the bond. I'm just curious about the order of which that happens. Do I wait until the next, I haven't done my first accounting yet. So do I wait till the accounting I provide that shows the value has increased, and then I simply get them, they tell me a new bond range, and then I increase that, and then I show proof that I've done that? Is that the right process?
You are just amazing. Yes, to one, think about that ahead of time, but two, know the process. What will happen, hun, when you turn in your petition, which we'll go through that sample later. When you turn in your petition, hun, you will indicate the amount of assets at the point you're filing that petition. And likely, very, very, very likely, the court will order you to increase the bond.
Yeah.
And at that point, you
I just
must
wanted to make sure I didn't
follow.
proactively need to
No,
increase
you
it. I'd
don't
rather
need to.
just wait. Okay,
Right.
cool.
Because it's a whole lot easier for them to increase the bond than it is to decrease the bond. So a lot of people, what happened even with stocks and annuities and things like that, let's say back 2020 and 2021 with COVID,
Right.
where stock market tanked, right? So you thought investments were 57,000, let's say our example, and they tanked down to 27,000. Trust me, I lost quite a bit
Yeah.
in that. And your bond
Fortunately,
is that
this money was flat during that time. That was when it was sitting before I could take possession of it. So it was a good thing.
nice, right? Nice. So what would happen is a lot of people would go back, or I've seen conservatorships where I was assisting a pro per, and because they use a lot of money for, and we're talking, this was a conservatee who was an adult young man, though, that had incompetence problems, medical problems. And so his medical training, assistance, rehabs, blah, blah, blah,
Right.
cost
They were
quite a bit of
spending money. Yeah.
So the money went through quite a lot, to where every time he files, so instead of filing, the dad is quite funny, but the dad's the conservator. Instead of filing a conservatorship accounting every 2 years, he'll do it every 1 year and ask the court to lower the bond amount, so it doesn't cost so much for the year to get the bond lowered, and doesn't waste a lot of money buying a bond because there's lower cash. So it goes back and forth both ways, but you'll know that in your order, hun.
Okay,
I mean,
thanks.
when you file.
Yeah, okay.
Okay, so again, we're finishing the form. So you would, if there is no attorney, you're completing this as a pro per. You also need to date here your name will appear here in the sample. It's done by an attorney, so this is the attorney's name. But for PERS, your name will go in both spots. And again, you will sign this, same as here. This, again, will not be done till it's returned to you by the probate referee. Once you have signed it, dated it, you know the form is complete and ready to go. You will turn it into the court, file it with the court, and it will get a filed stamp on it. And then you know you're ready to go on to the next steps. Now, again, it's really important because when you start your accounting, you're going to go off this date. That's the date you're going to start it. And you are going to start your beginning assets with everything on attachment 1 and everything on attachment 2. Rex will go through the accounting part and show you how that's done. And then I will bounce back in to go over the petition of how you file with the court to ask for approval of accounting. Are there any questions on the inventory and appraisal itself?
I have a quick question.
Yes.
Well, inventory and appraisal. I just wondered, do you get a hearing date after you turn that in?
No hearing date whatsoever.
Okay.
There's no need for a hearing on it. The hearing is only going to be when you do your accounting and your petition. You'll get a hearing date for that petition.
Okay, thank you.
You're welcome. Rex, you ready? I'm ready to stop sharing and give it back to you.
Yes, if you could switch the host back. I was looking for the host transfer and I could not find it today, so you need to transfer it back.
You're now the host. Click share your screen.
Okay, I will do that as soon as I get to all the pieces. Let's see, 3.
I'm going to mute also. Sorry, I muted before I finished. I'm going to mute also, so I will come back to you guys in a little bit.
Okay, can everyone see? Let's see, this says inventory. Let me get something else going here.
We can see your screen though.
Okay, so what we're looking for, it says, get the right piece. So it says summary of account and charges. All can see that? It's large enough?
Yes.
Okay, great. Yeah, because I had to put it at 150%, so the numbers were big enough. Okay, so let me I wanted to mention something about the inventory and appraisal. For more information on that process and the details, there's a probate referee guide that is free and it's online. And you can look up things about assets, and this is the state guide for probate referees, and it might be helpful in you being able to explain what the assets are and what the probate referee is likely going to be interested in. In terms of sometimes I've run across where husband and wife and it's all community property and one of the spouses becomes incapacitated. They get a conservatorship. Their attorney says, go get an inventory and appraisal. And I wanted to point out an exception to that. It's not fair for community property to have to do an accounting. So the probate code section 3051 and 3054 says that if the one of the community spouses is still not in need of a guardian, a conservatorship, there's no accounting needed. In addition, when there's less than 15,000 of assets, you can ask that an accounting not be required. Okay, so we're going to go through the forms And this particular form, GC 400, is like the spoke on a bicycle wheel. It is the center axle, and we go out and work on forms, and then we come back here to accumulate it. And this is always the top sheet on your accounting reports. So guardianship, conservatorship, if it's probate, you just write it in probate. If it's a trust, write it in on the top sheet that it's a trust. And whether this is the first accounting, 14th accounting, whatever it is, or if it's a final before distribution on a probate, opening date of the account, there again, it's the date you received letters, or in case of a probate, it would be the date of death. Through you have an inventory and appraisal due 90 days after appointment. The accountings are due at the end of the first year, and then every other year thereafter. So the accountings are due for years 1, 3, 5, 7, 9. And the way the form is situated, some of the formatting, when I'm going to be bouncing around quite a bit. In the lower left is a page number here. In this example, it's 21. So that'll help you get back and forth. If you printed out the materials, I suggest you yellow tab it so that, because we will bounce back and forth here quite a bit from other schedules. So we start out with how the form is situated. The terms that they use are, in my opinion, arcane, and don't really resonate with normal language. Charges and credits. Well, if you know accounting, like when I was in accounting school, debits and credits, okay, the debits are by the windows, we used to say. But in this case, what we have is charges and credits. Charges is what you're charged with, the responsibility of someone else's money. So that's things that came in or assets that you are responsible for. And then credits means that you're no longer responsible for those funds. They've been utilized, and that's the purpose of this accounting. The other phrase that comes in all the time in court accounting is the term carry value. Now, Tamara just went through in detail the page 2 of the inventory and appraisal, where the appraiser gave you the values of the assets at the date of appointment or the date of death, and that is referred to as carry value. That value does not change throughout the entire accounting process, even if it might go 9, 10 years. Carry value always remains the same. If you know a little bit about income tax, what we use in tax, we call it basis, but we don't use that term in court accounting. This lines 1, A, B, and C are basically a copy job from your inventory and appraisal. Just bring over the totals, and now you're starting the accounting process. The form is set up, I like to look at it like kind of like links on a website. So receipts during the period, Schedule A. Well, Schedule A might have several different parts. Interest separated from dividends, different, things like that, from sales. So if you picture links, and we're going to go out to those links, but they all end up coming back to this line as a total. And there are forms that give you indication of what the court's looking for. Here's receipts during the period, gains, other charges, and then if there's a business, which is rare, unfortunately, if you have a trust or an individual with a business, fortunately for the person doing the fiduciary accounting, all you have to do is bring in the net income from the accountant's reports, and you do not have to do the accounting for the entire business. Okay. The form has, in the lower part, we're getting into the credits, also known as disbursements, and the schedule, the set of Schedules C, set of Schedules D, and others. And then at the end of the accounting period, at the end of the first year or every alternate year thereafter, we have the balance of the assets at that point in time. And it's the ending carry value of what's left over after all the activities in the estate trust or guardianship conservatorship, and then the property at the end of the accounting period. So that's like the other end of the year from what we started with on lines 1, and now we're on lines 13. Okay, so the way this works is you start out with a certain amount of funds or assets, you add to it, okay, fine, you run a total, then you start showing what you spent money for, and then what you have left over, and then you get a total of the credits. Now, line 7 must match line 14. It's called balancing. Okay, you gotta balance, and if it doesn't balance, forget it. Don't even turn in your accounting because it's not going anywhere. It'll bounce. So even down to the penny, I kind of object to it. I think the courts are a little anal retentive in keeping pennies. With the IRS, we don't use pennies anymore. 50, anything 50 cents and above rounds up. Anything below 50 goes rounds down. But you're not able to use that convention with the court reporting. So we're going to go into detail of all the income items and disbursement items. The other formatting that I want to point out to you is that the form specifies that if you have nothing, like say on line 10 or line 11, that you put zeros. So you're making an affirmative statement that it's zero, not just, oh, I forgot something. And then in the lower left, this says adopted for mandatory use in judicial council. As I mentioned, judicial councils, like the board of directors under California Supreme Court, they approve all forms. They supervise the administration of the courts. They have open meetings, which are kind of interesting in San Francisco. And it gives you the form numbers. So mandatory for use in court for probates, guardianships, conservatorships, and it's also mandatory for court accountings that have to do with trust assets. In the lower right, we have some code sections, kind of a reference. Where did this stuff come from? If you are curious or trying to find out, what is the context for this form, they give you the probate sections, like accounting starts out at probate code section 1060. And then they also reference the California Rules of Court, which are online, 7.575. So more information is available in the code, and it might be helpful at some point in time. Okay. So what we're gonna do is go through the pieces of this and build the form. I'll just call it GC 400 sum. And we'll go back and forth here to page 21 in the handout. So the first form we have on page, whatever it is here, 21 1A, is the description of cash at the beginning, on hand at the beginning of the account period. In this case, it just mirrors the beginning inventory and appraisal. And you just list the value of the cash at that point in time. Nothing unusual about that. Then the next item we have, just like the inventory and appraisal, we have the non-cash. Now, in your first account to the court, you only show the carry value, basically like the probate referee outlined for you. And it just gives a starting point, kind of in a different format in future years that will match, like say if we had December 31 year end, you'll match what the ending was on the last account. It has a cross, like a footnote cross, that says for carry values, the assets included in inventory and appraisal, said where to get it. Fine. And then there's also an asterisk, estimated market value. What do we have here? You're not doing an estimate in the first year. You don't need it. It's not required. And when you get into it in subsequent years, don't knock yourself out about, getting an appraiser. Just use Zillow or Truilio or some of the other sites, and it's basically a guesstimate of the value. However, on marketable securities, it becomes a little bit more important because the ability of the fiduciary, trustee, executor, whatever, to manage assets sometimes might become into question, where the fiduciary gets sued for, say, bad management of assets. They invest in risky stocks, and you would take the stockbroker's report and show the value at the end of the accounting period, market value. It doesn't go anywhere. It just shows here. It's a disclosure. If the beneficiaries have an objection, they have a certain time period, they can file their objection in court. So this basically matches the inventory and appraisal like on our GC 400. Let me go down.
Wait, can I ask a question? I'm looking at
Sure.
the attachment, and at the top it says, I don't think I see it on your screen, but in my printout it says starting your second accounting, so the end of year 3. So we don't file this in our first 1 year accounting?
I would throw it in,
Okay.
but the second accounting in this case refers to what I was saying about the market value. When you're
Yeah.
just starting out, probate referee just gave you the carry value. That's all you're concerned with. So that's the interpretation of what I typed on the top.
Okay, so for my first one, I just
You
leave
don't
the
use
estimated
you
value
don't use
blank.
estimated
Okay.
value at all. You have the real value.
And then next time around you do it. Okay.
Correct.
Thank you.
Uh-huh.
I know you just said that, but thank you.
No, that's fine. The other thing I want to point out in terms of tracking, and this is from probate examiners that look over the accountings for the judges. When you put assets on your inventory and appraisal, give them an asset number and never change that asset number ever. Because it allows for readers of your reports to go through multiple years and track, say, asset number 7 was the apartment complex in San Bernardino, and they go to 7 each time. And it helps, especially if there's a lot of assets. And to carry that through, or to explain it another way, is if you sell the asset in one accounting and then it's gone. So that number, in this case 7, don't use that number again. So it won't confuse people trying to track multiple years of your accounts. Okay. So we just helped somebody recently on request for waiver. It was a small estate. There's a form, a waiver of accounting, so you don't have to do it. And that is form GC 410. And the reason why the court would allow this is that the assets are too small to warrant the account, under 15,000. So I just point that out. It is available. Now, this form, it says not to file it with your accounting reports, fine. Basically, what this is, kind of an accumulation page of all the sub-schedules before you bring it to the summary page, the GC 400. So I would have come up with a different system on putting this thing together, but they didn't ask my opinion. So all these income items or receipts are from the A group, and in our GC 400 sum, it is from that section. Property receipts during account Schedule A. Well, Schedule A is not just one schedule. That's the odd thing about it. You can have the dividends A1, interest A2, pensions A3, okay, ad nauseum. And then this is just an accumulation page. And then the total for all of the, in this case, receipts, then you would bring it forward to the summary GC 400 sum. And the same with disbursements. We're going to look at the sub-schedules, but in this case, we're saying C, which is in the disbursement section. And then they give it, C8 happens to be medical, paid for the ward. So it might help. I like it. As an accountant, I think it's easier for me to look at sub-schedules and then it summarizes before it comes to the GC 400 sum. But it's not required. So now we're going to dig through the nitty gritty of the detailed schedules. And the first one we have is on the Schedule A series. You can see it says A1, like we were just talking about. And this happens to give you the categories of receipts, dividends. All right, so if we have a Schwab account, you list every dividend that you received from the statement. You cannot combine numbers. So that goes with bank accounts and other things. This particular one has to do with dividends, but the point I was making is you, on any type of asset, you cannot, or receipt, you cannot combine them. We have a 4-digit date. Get in the habit, a 6-digit date. Get in the habit of putting 6-digit date on all of your statements, receipts, and everything, because it gets really confusing. People habitually use 4-digit dates, and then you're always confused about what year did that come from. Then you total on the bottom of each page. In the judicial council forms, you subtotal each page, you do not accumulate to the next page. Okay, now we were in dividends, now it says interest. Okay, and on Southern California, I just used the last 4 digits of the account number. That's enough detail for them. You're going to turn in original statements anyway to the court, so they'll be able to cross-reference. We're only going to go through a few of the judicial council forms, but there are 48 different forms that are possible. So when you're looking around for a certain kind of income, you can get on the state's website and look, what names of the other forms are to report your special type of income. And frequently, let me go back to dividends here. Say you have funds or an estate, I'll call it an estate, whether it's a guardianship or conservator or probate, that has a large stock portfolio. So you get the dividends, and there's a process that's really common called a dividend reinvestment program. So you get a dividend, say, hey, I got a dividend, buy me some more of that stock. And it's common. People do it all the time. If you're doing fiduciary accounting, you got to stop that, not by law, but by self-preservation. So the problem, dividend reinvestment program is abbreviated DRIP. And the problem with the DRIP is that every time you get a dividend, you're posting it on dividends. Okay, fine. Now, dividend reinvestment, now you just bought some more assets. So now you have to go and put that dividend reinvestment on the asset schedule. 0.037 shares of Whodunit Inc. And it drives you nuts with all the dividends. So if you have a portfolio like that, just tell the broker, stop the dividend reinvestment program, wait till the cash gets higher, and then reinvest the cash all at once at a later date. That'll save you a lot of work. Okay, so interest, nothing complex there. Then receipts here we have for pensions, annuities, other periodic payments. Just listed as it comes in. Receipts for rents. You end up having to split out the rents. Like I do a lot of tax, so I would never put rents on one schedule by itself, but it's done this way here. So let's say you have a couple rental properties, and you put one property and list the rent each month as it comes in. And then the other one, combine that with that particular property. And by rents, it means a passive rental income, like renting a house or a condo. It would not include like an Airbnb or a motel or bed and breakfast. Those are businesses, not passive rentals. So you would isolate those as more like business type assets.
Rex, I
Go
had a
ahead.
question on Schedule A. On the Schedule A, which one do we report for like your checking account and the interest? Is it under here or no?
Okay. On A2 is interest.
For the receipts interest standard account,
Yeah.
that one?
Yeah. So yeah, it's kind of goofy. All of them are GC 400. Well, whoopie-doo. And then we have all of them that are A. So really the only difference in, types of income and stuff is that last numeric, 2.
Right. I mean, that's
So,
why it was kind of confusing, and that's why I wanted clarification, because I'm trying to figure out, like you said,
right.
we
So
have to
if we
put,
were on dividends still, it's A1. But now that we're talking about the interest from whatever source, bonds, bank accounts, would go under interest
okay. Thank you.
for A2. Then we're going off into A3, and this is pensions, annuities, other public benefits. You just list each of the pension payments. Nothing unusual there. Generally, you're going to be pulling it from the checking account anyway, from direct deposit. And then total the bottom of the page for this particular page, but not cumulative with the prior page. Rents, I think I was already here before. Maybe I'm just repeating myself and don't know it. Could happen. Okay, now we're on A5, receipts, Social Security, veterans benefits. So a few years ago, we had the new probate referees at our Contra Costa Court all have to take our class. So we had a probate referee in class, and she looked at this page and blurted out, "You can't do that." What? You can't do that? Okay, what can't you do? You'll see here that it shows 3 payments. You cannot list combined anything in court accounting. Every penny in, every penny out is accounted for. So you would have to list those individually to come up with, like, say, 9 different transactions. Okay, then the question comes up about what do you account? Like on Social Security, there's a gross number, but they don't give you that amount of money because something got split off. In this case, Medicare. So what you're accounting for is only the cash that you have control over. So you ignore that there was a Medicare Part B. You didn't get it. You didn't see it. You can't control it. Don't report it. So that's a netting of a transaction before you get funds. I'll give you a different example that also has netting. Netting means you take a plus and a minus, and what's the total, and you report that. That's netting. In accounting, we don't do it. It's not a good idea anyway. Let's take rental income, for example. So if the rental income is $3,000 a month, and the tenant said, "Well, I'll fix the back porch for $500 and we'll take it off the rent." You cannot net that and show just the 2,500 for that month. You have to show on the accounting the rent was 300 or 3,000. And then the 500 for the repairs would show as a disbursement. So it would not be netted in that example. Receipts, other receipts, G6. This is basically, you can call it miscellaneous. Anything else you couldn't figure out by another form, you can put it under this schedule. Health insurance, state tax refund, little refunds and things. So just use it as a miscellaneous. Okay. Now, the other, see, we switched here. Now we're in the B world. When we were on the Schedule A world, that was like funds coming at you. And now we're on GC 400B, where this is gain on sale. So you sold something, and we have an asset number from our inventory and appraisal, date sold. We had a carry value, and then we have a sales price, which is the contract price on a building sale. And then we have a hypothetical gain of 19,000. Well, you and I know that's not really a gain. We have a thing called closing costs, and this form is ignoring that. And that's correct. The form wants you to ignore it here. So it's basically sale from carry value to sale price on the contract, which is just one number. What you want is on real property, you look for the final closing statement, not a preliminary closing statement, because they might change it later. So the form says there's a gain of 19,000. Rick says there's no gain of 19,000, but I'll show it how you want us to. Okay, and we'll get to it later. See, we're on the income side. Later, we'll get to disbursements, and that's where we'll pick up the closing costs from the real estate sale. Okay, so now we have, we're in the C world, disbursements, 400C2. And this is, the particular one is the conservatives costs, like care facilities. We have one client that's paid about 150,000 for a year of care costs. It's unbelievable what it costs. It doesn't pay to get old or sick these days. I mean, I would avoid it if I were you. So in this, you just list what they are. If you want to, you can break out separately in convalescent homes. Sometimes they'll have other expenses, meals, field trips and things. You can break it out those separately if you want, or just leave them into this statement for what's being paid there. And you'll notice we switched here. So actually we switched directions. I need to go back to do something else. So it says gains, which is money coming in. And we're on the B series. Now it says disbursement. So the funds are flowing the other direction. So we have to stop at the B level because the GC 400 wants summaries. So back on page, whatever this is, 21, now we have to enter the totals from all the subschedules on Schedule A that are here, and then all the subschedules for Schedule B and enter it here. Before we can move on to disbursements, which we'll do next. I'll show you later on an Excel spreadsheet format that you can use for report accounting. But no matter what, if you use the other format, you still have to put this GC 400 sum on top when you turn it into the court. So I'm going to we're going the other direction, disbursements. So I'm going to try to find my page where disbursements start. There we go. So we had living costs, C2. Now we have distribution or disbursements, C5, disbursements general. So there are other types, but this is kind of a miscellaneous schedule. We have the conservator reimbursement for costs, attorney's fees, filing fees, things like that. Those are reimbursables. If you're doing a probate, actually guardianship and conservatorship, do not pay yourself as fiduciary nor the attorney. You cannot do that until you get a court order. So these are reimbursements, and when you petition the court for payment for your trustee or executor fee, then you can pay it, but don't make that mistake because the judge will call you on the carpet for taking anything for yourself without court order. Then we're moving on to living expenses. List what they are: telephone, supplies. You had a birthday party, okay. Disbursements, medical. List what they were. If there's something that looks unusual, or you think someone might take it as unusual, describe it so the readers can say, oh, that looks unusual, but this is why. You tell them within the account. Then we go on to C9, disbursements, property sale. Okay, well, we just sold a house and we had a gain that I objected to the dollar amount, 19,000, but now we're on the disbursement side and we take the final closing statement from the title company and we list here the costs for the sale. And what we have here, generally, I'm also a real estate broker, but it's irrelevant here, but you pull off costs that are what are called non-recurring closing costs, which means that it only happened once because the house sold. Now, recurring closing costs are like prorations, like insurance. Well, that's more of an expense item. A proration on property tax. You paid it ahead and now you prorate it back. So these costs are non-recurring closing costs that were paid out of escrow. And if they happen to be recurring closing costs, you would put those on respective schedules of income or disbursements. Okay, so on that house sale, we had 16,000 of costs that are shown here. Then money went out to pay off the first loan on the property. That shows as a disbursement. If you know tax, the court accounting doesn't match tax at all. But the flow is helpful if you're doing, like we do the 1041 fiduciary income tax returns. It's under a whole completely different system because that's federal law you're following, and these court accounting is all based on state law. The next disbursement, it's actually the same form, but we sold personal property. There's a 20% auction fee for selling personal property. So that is a disbursement. And now we have rental property on Schedule C10 disbursements. And I don't like the format of the way we're supposed to do this. I like Schedule E in a tax return. It shows the income and the expenses by category and the net. But we have to split it out for this purpose. So if you have more than one rental property, I would include all the expenses for one property, and then the next rental property, show all the disbursements for that. And disbursement, notice that we're not allocating between principal and interest. It's just the payment. So if you have an impound account and your taxes and insurance are included in your payment, this is what shows here, the amount that came out of the checking account. Now we have C11, other miscellaneous disbursements, tax repairs, federal tax, list those kind of miscellaneous items. And now we have, before we looked at a house sale and it was at a gain. Now we're in the money going out phase and we're showing a loss. So here we take one of the asset numbers from our inventory and appraisal, an Oldsmobile, junker, and it had a carry value of 3,100. We sold it for 3,000. Now it shows as a loss. And we will never use that asset number again for that Oldsmobile in future accountings. And I wanted to point out some other issues. All these forms are available online. You can get them. They're on the government website. They're all separate forms. And if you're trying to use the government forms, it's kind of a nuisance because each one's a separate form and download it and fill it out and okay. But I wanted to point out that on the website from Riverside Legal Aid, they have all of the Judicial Council accounting forms all in one long PDF. So they're all in one place instead of all separate pieces. That's riversidelegalaid.org. Another thing I wanted to point out was some of the common errors that happen with court accounting, some of the common problems. One is the GC 400 doesn't balance. And another is, how does the expense benefit the ward? So an example there would be, let's say the guardian or conservator put a hot tub in. Well, is that for personal use of the conservator? You'd have to explain. So it says the ward had certain medical expenses or medical conditions that doctors prescribed getting a hot tub. So let the readers know. Other errors, accounting for things that the fiduciary has no responsibility over. You have to control the funds. Also, confusing fiduciary accounting with other accountings. When I went through accounting school, not one word was said about court accounting, ever. And there's a potential problem I'll warn you about, that if you hire a service provider, let's say a CPA or non-CPA enrolled agent, CTEC licensee, and they say, and you ask them, can you do a court accounting? Oh yeah, I can do court accounting. No problem. Well, it might be a problem because I've seen it. What happens is the person doesn't know they don't know accounting, and they put it in a normal business accounting format, like an income statement. The problem with this is that the fiduciary hired and paid for a service that's not usable by the court. And so the courts would charge the fiduciary to pay out of their own pocket for making that mistake when your service provider didn't know what they were doing and doing it in proper court format. Other problems, writing checks to the fiduciary, paying beneficiaries before authorized.
Rick,
Out of state property. If you have a rental out of state or another, you don't account for it. For some reason, it's only what's in the jurisdiction of California.
Rex,
Yeah.
hey, if you like if you reimbursed yourself because you put out, like, say, court costs or for other costs, like, my mom has a car, and I was paying her car off, and then when I got control of the estate, I reimbursed myself because it put me in a bind. So that's not okay.
It is okay.
Oh, okay. I thought
Go
you
to
were saying
page,
that you
no,
can't
it's a
like
different
reimburse yourself.
context. It's a different context.
Oh, okay.
You basically contributed money to the fiduciary and then dispersed it. So on page 31, we show reimbursements. So you
Okay.
describe what it was paid for. The check just happened to come from you, and it's not uncommon
Okay,
for
I
that
just
to
was
happen.
making sure because you said something about being called to the court if you did something like
Okay,
prior to that.
let me draw the distinction so you're clear on it.
Okay,
These are
thank you.
reimbursements cost. You fronted the money. Now you want to get made whole and zero out that loan, and this is proper. You
So
have a
it's like
receipt.
an IOU kind of thing.
It is. But what I'm trying to draw a distinction of the other way was you paying yourself for services. That you cannot do.
Okay, I see what you're saying.
It's a big difference. I put it in my pocket. I earned it. I'm keeping it. No, you're not. Not until
Okay.
the judge says you earned it. You
Okay.
haven't earned anything.
Okay, this is just reimbursement for costs that were expenses out of my pocket, and then I'm getting paid back.
Correct. So you look at it. What are the steps involved? You had
I'm
money.
sorry.
Go ahead.
Sorry, this is Tamara. I'm in interject on that a little bit and say that, and I'm not saying he's wrong, but I am going to state if you prepay for property tax or anything of that nature, you cannot reimburse yourself until you ask the court for reimbursement. So let's say you pay property taxes for the conservatee or the decedent. Even though it puts you in a bind, I'm sorry about that, you cannot reimburse yourself. You ask for it in the petition, you ask for reimbursement. And so any expenses that you pay yourself out of your pocket does not go on your accounting. It is only asked for reimbursement when you complete the petition. So it's a little bit different. You truly, if you've already done it, there's nothing you can do. You have to state you reimburse yourself, but
Right.
technically you are not allowed to reimburse yourself for anything until you get court approval for that reimbursement. And courts are very, very for stuff like
You
funeral
mean like strict?
expenses.
Yeah.
They're very strict. And like funeral expenses, on funeral expenses, you as the conservator or as the administrator are technically supposed to file a creditor claim for funeral expenses and anything to do with funeral expenses. And then the creditor claim is either approved or not. If you don't do a creditor claim, when you do a petition, the courts are now requiring the beneficiaries to agree to you being reimbursed your funeral expenses. Now, I'm only talking funeral expenses and that nature. The court will ask or force you to include now a declaration by each beneficiary that they agree to you being reimbursed funeral expenses. But regular expenses, you have to wait, and then you turn in an invoice when you do your petition that says you fronted all this money and you want reimbursement, and then the court will approve it. Please do not reimburse yourself even if you're out the money and it's devastating to you, you should have wrote the check from the estate account. But if you had to do it before you establish the state account, do not reimburse yourself until you get an order from the court to do so.
Even if like you were paying, like we're paying her assisted living that she was paying, prior, because I had power of attorney, but then, when they die, the power of attorney is gone. So I was paying out of my pocket too for her assisted living costs.
Well, then you cannot get reimbursed until
I
the
have to.
court approves it. But you should have been using her money to pay now that you have your estate account.
Oh, I am now, but I meant prior to that, before I didn't have access to it. So what could I have done? I couldn't do anything until the probate, went through and I got my orders, my letters.
You cannot get reimbursed until the court orders it, sweetheart. I'm sorry. That's just part of the.
So what do I do now? Do I just put it as part of the accounting and then, whatever happens, happens?
Typically, I would put it as the accounting, and then when we do the petition, I'll go over how you state that you prepaid this, you reimbursed yourself, and you not asking for further reimbursement.
Yeah, because I'm just basically I have proof of all this because I kept all my receipts and everything that I can get.
But the court is not going to like that you reimbursed yourself without their permission. They understand, just understand.
No, I get what you're saying. It's kind of like I'm, being shady, kind of, I guess.
Not really. No. It's just you have to get approval for only the administrator or a conservator to use somebody else's money.
Okay, because looks like I'm taking advantage, kind of, or something.
Whatever the purpose.
Yeah. I get what you're saying. I get what you're saying.
Be careful, please. Don't do it. Don't.
I have a question, Tamara. What if in this circumstance now she put the money back in the estate and canceled the transaction and then asked the judge for reimbursement later, now that she reversed it?
She can do that, but it still is going to look the same. I mean, she can, but
it's still going to look like I borrowed it or something, huh?
Right. She already did it, so she has to move forward. I'm saying in the future, please don't do that. Not even expenses. Unfortunately, when you take on the role of being a power of attorney or being a administrator or whatever you want your title to be, that is, you're going to help that person, and then you wait for the court to say yes. Because what if you make a payment that's for something that's odd and the court doesn't approve your reimbursement? Now you're having to owe the state back and blah, blah, blah.
Right, maybe interest too.
And in some cases, the beneficiaries don't agree to you paying what you paid, whatever. You let the court decide if it was a proper expense, etc., and then you get reimbursed. But if you've already paid yourself, I'm telling you, I have many conservatorship cases, particularly where the conservator had to pay back expenses to the estate and they didn't have the money to pay it back, and now you have all kinds of problems. So the court does not allow you as the person in charge of the funds to pay anything back until they approve it.
Okay, thank you.
Thank you for that clarification, Tamara.
Sorry, I'm not.
No, I appreciate it.
But to the whole thing, but little things, I just want to be clear. Please do not take any money to yourself or reimburse yourself or anything until the court approves it.
Got it. Okay, so we're getting back into the disbursements, and we went through several subschedules for the disbursements. Now we'll go back to the GC 400 sum on page 21 and enter those disbursements by schedule number before we continue to back on page 39 where we have the ending values. Let me see if I can find a 39 here. Non-cash, this one's cash. Okay, on page 39, we're looking at the end of the accounting period. We just list the balances. If the balance doesn't show on the statement on that particular date, do a bank reconciliation to that date to get the number that you need. And the cash on non-cash on hand at the end of the account period, we've already discussed taking your carry values from the original inventory and appraisal, bringing them forward. And then you just come up with an estimated market value. It may be the same, may be different. Don't worry about risk on estimating the value. Just do a good faith effort to get a fair market value and don't worry about it. It's not like the court's going to hold you in contempt because you didn't estimate that right. Then after the ending assets on hand, we go back to the inventory and appraisal, the GC 400 sum on page 21, ending cash, ending carry value, total property on hand at the end of the account, and if you're lucky, the total charges and the total disbursements balance. It's no fun when it doesn't balance. One way to reduce your chances of imbalance, I am old school, I have an adding machine with a tape on it, but most people are doing things on computer, but it shows what numbers you keyed in. If you get into the habit of checking your input numbers on anything that you're totaling before you enter it in the court accounting, that might be helpful. Okay. And it's not in your material, but I touched on it briefly. Schedule F, change of form of assets. So if something switches out, like you had a B of A account, you closed it, and then you opened the same balance in a Wells Fargo, that's a change in form of asset. If you have stock dividends, that can be a change in form of assets. They just need to know where the funds went. Okay, now I'm going to switch gears for a second and go into an alternate way to do the court accounting. We've been on the judicial council forms, and now I'm going to show you a different way, and that is on Excel or on a program for court accounting. We start out with summary of account, just like the GC 400 sum. You can see that we're talking carry value, beginning of period, all the receipts, and then all the disbursements. This is essentially like the GC 400 sum. Get that form out here. But when you do that, you're going to turn it in. I suggest you just go through the extra effort and duplicate it on a GC 400 sum before you give it to the court. Now, let me get some thumbnails here. So go ahead.
Sorry, I'm going to add in just a little bit. If you're doing a trust accounting only, this summary of account form would be acceptable to turn in the accounting to beneficiaries. But if it is a conservatorship, a probate, or a guardianship form, you cannot use this form. You have to use the GC 400.
And I'll clarify a little distinction in what Tamara said was, if you're a trust and you turn this into the beneficiaries, that's okay. But if you're a trust and you turn it into the court is going to require the GC 400 sum. Okay. Now, I look at this court accounting with the Excel as a work of art. I mean, it's pretty slick, in my opinion. So we have the assets beginning of the accounting period. Fine, we show them. And by the way, this is in your handout number 2. You have an example of this. So this is basically property on hand in the beginning. And now we have, we're going to go through the receipts, but it's in 2 separate different formats. First, this particular accounting shows it chronologically. All the income coming in chronologically, fine, until we go through the full year. And that's turned in, I'm looking for something else here, chronological still. And then after that, we have receipts still, but now we're going to show them by category. And so it's the same data, but it's more in a usable format. Here's all the funds from B of A, from other vendors. So the court sees it both ways, and this is fine. They accept this. And you'll notice that we're not using the judicial council form numbers, the 400 A4. This is in a different format that they will accept. So receipts by categories again. Let me burn through here. We have gain on sale, which you have to show those separate. Now the disbursements, same game, that we show all the disbursements chronological. And then by the next, the same disbursements we show by category.
I'm going to pipe in here just while he took a break in his wording. He passed through a few slides. But if you're going to decide to do it this way on Excel, if you go back to the assets on hand at the beginning of the account period, you must have a market value category. You cannot just turn in a carry value category. You must also have a market value category on this form. And he's printing. And so you can do it this way, but again, you have to add a market value category. And then when you go down to slide down, Rex, because there was another one. And then when you go to how this would be okay for a trust accounting, but this would not be okay for probate, conservatorship, or guardianship accounting. So when you go down to the chronological, the courts will not accept this chronological stuff. So I myself would not even include it because the courts won't take it. But the rest of the receipts part by category is how you would indicate. The only other thing I want to make sure it's really important, which I see because I'll tell you, I am hired by a lot of law firms to review other accountings and or complete accountings. And I see a lot of lumping. So if you take his first one, dividend income for Honeywell, people will say 614 through 36 and they'll give a total of 103. You cannot do that. It has to be listed individually, like he has listed it individually here. And I myself would have put another line item above that says amount right next to the dividend income amount. And then I myself put total dividend income as indication, and then the 103 to 20. So I myself, I am constantly, the courts, I've had a lot of courts where they've said, they've referred me and said, Tim, please help them correct this. But they're looking for specific things, and so am I when I'm reviewing another accounting that's turned in, because maybe I'm reviewing it because I'm on the beneficiary side, not working as an LDA, but more a paralegal. So I'm looking for specific things, and I need to see each individual item listed. I go through them, and there's certain things that I'm looking for. So this is very good, but in that it tells every single line item, do not lump and just do one total. But go ahead, Rex, with it.
Okay, thank you for that update. So we're going through gain on sales. We already went there. Disbursements. I was unaware of the chronological. The courts didn't like it. I thought they did.
No,
And then we have losses. Before we get into this section on distributions to beneficiaries. And then the last page is property on hand at the end of account period that ends up being brought forward to the summary.
again, this one doesn't have market value, and it would have to have market value.
Okay. So that's another format, if I can get my screens worked out here. Okay, so I want to just tell you in your reference material about handout number 3 that we provided for you. Reference material. So we have links to various things. And what I did is I summarized from court websites things that they thought were important related to court accountings. So it's in a different format, and there's not too many pages of it. And then this is, if you're trying to allocate assets and you don't know where to put it, say example you have, it's called a split interest trust. So one beneficiary gets the income, somebody else is going to get the assets at the end of the trust or estate or whatever, probate. So it's split interest. So in your accounting, you need to know whether it's going to be principal or income, because the income goes one way and the principal's going somewhere else. This is a summary of code sections to help you make that determination, whether it's principal or income. This is a sample. We have a spreadsheet that we sell. I think it's $50 on court accounting. It's just for a basic Excel spreadsheet that we make available. There's a form in there. And then the next thing I included, I got these from the probate examiners from Contra Costa. Alameda counties are a little bit more detailed. The probate examiners go through your accounting and they look for these items. These are their forms. So you can kind of proofread your accounting before you turn it in to see if there are things that they might want to kick out. And so that's that thing. And then the other thing in your material, if you wanted to fill out an evaluation, that would be fine. We'd be happy to have it. And then if you want to, I can't move this thing. Anyway, we have completion certificates if people who want them. There's no MCLE credit, but if that's of interest to you, these fine certificates and about $6 or $7, and you can buy a coffee at Starbucks. So that's the part I wanted to cover, and from the basically my section work in every side of the GC 400, and I think you have a better idea of how that form works. So with that, I'm going to turn it back over to Tamara. Let me see.
Thank you, Rex.
You're welcome. Okay, I'm looking for transferring control again, and I'm not seeing it.
You have to hit participants,
Okay,
me.
yeah, I got it. Make host. Okay, Tamara, you are now host.
Hey, Rex, you mentioned the Riverside Legal Aid website. I've
Yes.
been poking around on there and I can't find any forms anywhere. Any idea?
Just a second. Let me flip to my page.
All you have to do is type in on the internet, like for instance, GC 400 or whatever form number you're looking for,
I
hun.
was looking for a combined one. That was what
Yeah.
I was kind of poking around as
Yeah,
well
the
while we were
combined
chatting.
one from the Riverside, it's riversidelegalaid.org.
Yeah, I'm there. I'm on their website.
/documents
Oh,
/standard-accounting-forms
oh my God.
-1 PDF. And this was from June 2024. I can't guarantee that they'll keep it up on their website.
Okay. So it was their website and then it was resources.
I don't know the
Okay.
subtitle. It's riversidelegalaid.org.
Okay. I'll just, yeah, thank you.
You typically won't find them, hun, in one lump thing, but it's very easy to just type and download them
Okay.
separately.
That's fine.
It doesn't matter what court you're on, they all use the same forms.
Okay.
Okay, so I'm going to start off. Hope you can see my screen. So I'm at the I'm doing the petition portion. So you've already completed the accounting, and so now what do? You have to complete a petition and attach the accounting to the actual petition. So I'm going to go through how do you complete the petition and what information's needed and how do you go through all of that. So to be able to complete a petition and turn
Can you
it.
tell me, I'm sorry to interrupt, can you tell me where on the forums we're finding that page?
It is in the handout number 1,
Okay.
and it is page 12, hun.
All right, thank you.
You're welcome. So what it is you're going to, you can download from the internet what's called pleading, PLEADING paper. If you just go on the internet and type pleading paper, you will get likely a Word doc where it will be numbered along the side, and that's called pleading paper. So you will start with a completely blank form. It won't have anything like it that's on your sample. You will need to create this form. So I'm going to go through each line item, what you would put on there, etc. So again, your form will be blank. And what I want to do is I'm going to take and make this a little bit smaller so I can see everything on there. Okay, so again, this will be a completely blank form. You are going to start this with this is kind of all this up to about line 17 ending is what's called your caption. So a lot of times with examiner notes, etc., because realize when you turn this in, you're going to get examiner notes, and I'll go through that at the end. But a lot of times they'll say something about the caption. If anything's mentioned about the caption, what they're talking about is like from line 17 up. Okay, so you would start it out with your name on line 1. It will not be the law firm, but it'll be just your name and your address, phone number, the same type of information that you put on the inventory and appraisal in that part. Now, attorney for, typically, if you're pro per, I would not put the words attorney for. I would just put your name, again, comma, if you're a conservator, administrator, a guardian, and then comma, pro per. Again, the pro per just indicates that you are doing it yourself, and there's no legal representation completing this for you. You must put the court name, again, whatever county you're in. So you would just copy this line and change the county. Typically, I'll put this and then county on the second line, but you can do it this way also. And then down here, you wish to put, again, conservatorship. If there's two different ways you can be a conservator of just the person, conservator of just the estate, 3 ways, or conservator of just the estate. If you were a conservator of the person, you would not be completing this form, because that means you're only helping make medical decisions or placement in a care home or anything of that nature. You're not handling money, which is estate. Okay, so it could be, for probates, I usually put estate of, and then the name, and then decedent. For guardianship, it would look guardianship of the estate or guardianship of the person and estate, and then that. Conservatorship, I would complete it this way. So, Jeannie, you always need to remember that if the person went by something other than their legal name, so this would be their legal name, and then this is what they're known as. I don't also put also known as, I just put AKA, and then in parentheses, I'll likely put all the names if they went by a different name. So like if they typically go by their former name instead of their married name, or sometimes people go by their middle name instead of their first given name, you need to really make sure you list their legal name and then what they're also known as. And then this would be conservatee or minor or decedent. Case number goes over here on this side. Typically, I separate. I don't combine these together like this. I will put a space and then drop this down. Remember that this part right here, these lines right here, state exactly what you want the court to do or what you're talking to the court about in this petition. So it can vary. It may not say this. It might say more than this. It might say less than this. So we're going to go through that. In this sample, it's the first account. Now, this could be your second account. It could be your third account. Sometimes when I review accountings and they're incorrect, and the person needs to write amended first accounting, meaning they turned in an accounting, it was not accurate, the court would not approve it, but now I've helped make revisions and get it correct, so it needs to say it's amended in front of it, meaning you did turn one in and now you're changing that, you're amending your initial filing and now you're changing it. It could be, things like that. So don't actually follow this sample in so much as make it what yours is, not what this says. Because I've had a lot of people where I've reviewed like a second accounting that they did using our samples and they wrote first account. And I'm like, but you already did a first account. So just know this is just a sample. You'll make this what your petition should say. So first account current, report of conservator, or it could say report of administrator, report of guardian, and the petition for its settlement, meaning you want it approved. In this case, or in this sample, in this accounting we did, there was a sale of property. It could have been a sale of a vehicle. It could be sale of a property. I don't put this in mine, even if I do have a sale. I just don't put it in the caption. There won't be no problems if not. So, and for allowance of conservator and attorney's compensation. Again, remember, a conservator, a administrator, a guardian cannot be paid any fees prior to court approval. If you don't have an attorney, don't include attorney compensation in there. But there are other things I also include in my title. For instance, if the conservator is asking for reimbursement, it would say, comma, reimbursement of prepaid expenses paid by a conservator or something of that nature. Typically, even when I'm doing these for attorneys, I'm asking for an attorney reimbursement of expenses paid. I could be, sometimes there's in a decedent state, you're asking for a reserve, meaning hold back a certain amount of money so that in case you have any other expenses closing, that you have funds that can be paid, just things of that nature. So right here is the caption on telling the court what you're going to ask for in your petition. You would include date of hearing. Now, in this case, the sample shows a date. You will typically not have a date. You will leave this blank because when you turn this petition into the court with your accounting, the court will return it back to you, or the file clerk will return it back to you, and they will put a court date in here. If you have a court date in here and it's not one that the clerk, when you file it, agrees to or says you can have that court date, they could reject it and say, why do you have a court date there? Or you cannot have a court date there, or whatever. So you would leave it blank. The time also, I leave blank. I'm sorry, I indicate time, but I leave it blank where you enter the time. The clerk will enter that for you also. Department, I always know what department I'm in, or what I'm filing in, so I do include the department, and I never include the judicial officer. The reason why I don't even include the wording there, it goes down here in mine. But I don't put the judicial officer because of the fact that a lot of times, even though you know who your judge is, that person might not be the judge that day. They could be on vacation. They could be handling other cases. You could have a pro tem sitting in. You could have the courts change judges all the time, or let's say, puts them in different departments because they need more help in other departments. So they may have a different judge sitting in. And what that causes is if you put the judge there and that's not the judge who hears the case, they have to cross it out. They have to put their name, they have to initial, and it's just kind of makes the petition a little messy. So I don't include that. Now, when I start off down in my wording, so now you're talking about what am I going to do? What am I asking for? I typically start with name, so your name as the petitioner. I will put in quotes. I will quote the word. Typically, I'll quote petitioner and I'll quote conservator, because as I'm talking in the petition later on, see, I'm only using the words petitioner. You need to state, what does petitioner mean, or who the petitioner is. If I quote it up here, it means for the rest of the way through my document, when I refer to petitioner, I'm referring to myself as David, or I'm referring to myself as my name. And then later on, I'm going to just say conservator did this. So again, by putting it in quotes, I'm saying conservator means me.
Can you clarify? So I have letters of guardianship. So am I guardian throughout, not conservator, or are they interchangeable?
You are not conservator, hun.
Okay,
A
great.
guardian is a person that's appointed for a minor under the
Yes.
age of 18. A conservator is appointed when the person is over the age of 18. They have two distinctive different titles. So you will always be the guardian. So you will be the petitioner and the guardian.
Thank you. And then where it identifies the, in this case, Jeannie as conservatee, what is the designation for under a guardianship for that?
Minor.
Guardianee? A minor. Okay, thank
You're
you.
minor.
Thank
Just
you.
like
Yep.
what you marked as we
Yeah.
went through the
Of course, that
inventory and
makes sense.
appraisal, what you marked as that is what carries forward, hon.
Perfect. Thanks.
Okay. So then you're going to state as conservator, as guardian, as administrator of the estate and the person, which this should have stated the estate and person, because it states it up here. You wouldn't be doing this if you were just as of the person. So of Jeannie, so your person, whoever your person is, who is the conservatee, who is the minor, who is deceased, and I present for settlement and allowance my verified first account. And so I always repeat exactly what I've stated up here. I repeat in this sentence down here. Okay, so all I do is copy this and bring it also down here. So I've repeated what I'm doing or what I'm asking for. And then I, as the petitioner, am respectfully stating these particular facts. When you're submitting documents to the court, it's very important for you to understand, in legal terms, it's called Your papers should stand on their own, and that's used very often. And what it actually means is you are never to tell the court, go look at my papers. You can tell when I was appointed. Go look over here. Go look over there. No, that means your paper doesn't stand on its own. I should be able to pick up. And again, I tell you, I work for I'm completely independent. So a lot of times law firms will hire me to review accountings or do accountings. So I'm doing probably 10, 12 a month. I need to be able to pick up this petition and know exactly what's going on with it just by reading your papers. I shouldn't have to look at your inventory. I shouldn't have to look at your orders. I shouldn't have to look at anything because you're telling me everything within this document. So when I say your papers must stand on your own, I should be able to read what you write and understand your case no matter who I am, and I may not even know you. Again, that's having your paper stand on your own. So what you're doing is you're telling the court so that they can read it within your document that I petitioner, was appointed on March 8th. Remember, this date is the same date as the inventory and appraisal date. And I received my letters on a different date. Why would there be a different date? A lot of times you'll have a hearing on a Friday. Let's say this was a Friday, March 8th, and the court ordered a bond. So it took you a few days to go apply for the bond, get the bond company to send you the documents, fill them out, you pay for it, blah, 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 blah. And then you turned it in into the court. So your letters could be at a different time frame than your order. So you want to make sure you tell the court of both dates. So this is really your kind of official. Your letters are like your license or whatever. The order is when the court said or had the hearing or approved your petition. Okay, so at all times during this appointment, I have been acting as conservator, or all times during this appointment, I have been the administrator, or I've been the guardian. So it means there was no break in timing. The difference, or you would say, when would that come into place? I review a lot where, say, for instance, at the beginning, there was a public administrator, or they hired a private fiduciary until you got your papers together and you applied for your appointment. You would really need to state all of that in this, and then you wouldn't be responsible for the time period that you weren't ordered responsible, but you would still indicate it in here because they're looking at dates. They're making sure they're looking that your accounting starts on this date. They're looking at certain things. And so within this, you're telling it all to them. So number 2 would be inventory and appraisal. So you're stating an inventory and appraisal was filed with the court on what date. That's why I always like to look at what date you filed it. And in this case, you submitted showing of value of 1342,25859. First thing they're going to do, and the first thing I do when I review accountings, is I go, okay, they state in here, inventory starts with this. My beginning assets at the beginning of the account period better equal this exact same total or something's wrong, right? So they're matching. They're taking 2 different documents and kind of matching and seeing what you're doing and making sure it all coincides with each other. I add a footer in mine. I do not put it this way. I add a footer that uses Jeannie Gray. I want it at the bottom of this page to state who the account's for. I will put this over here in this left stating it's the first account of the conservator. On the right side, I repeat the case number, and then I will put a page number, because I want all my documents to tie. And you will see this footer will carry forward to our page 2, where up top there's no indication. So say this page gets separated from the first page. When we used to have to file these paper form and not electronically, it could have been a chance that this page gets separated. If my footer only says this, how do they know what this page goes to or find what case it's for without me putting the footers that refer back to what my case is, what my case number is, and what I'm doing here? So that's what I like to do. So number 3 is period of account. So you're stating that this account is covering this time period. Again, it should be the date you were appointed, and the date that's on the inventory, and the date of your accounting starts. Your second one is charges and credits. I typically don't use it this way. What I do for my charges and credits is I will repeat let's see if I still have his stuff up. GC 400. I take this GC 400 and I state property on hand at the beginning. My cash assets were this, my non-cash assets were this. My total property at the beginning was this. And then the second part I end is my cash assets were this. So I kind of repeat the GC, but you do it, since this is the title, it's okay to do it exactly how this is done. I just put a little bit more information in mine. And law firms, I know there's several on here who are learning, typically do how I do it, not just this blanket thing, but this is okay for preppers. Authorize investments. It's very important when you become a conservator, a guardian, and or an administrator in a probate, that when you open a bank account, it must, I cannot tell you enough, it must be in an interest-bearing account. Even if the amount's like, well, gosh, I only have $500 in the account, why bother with that? You must put it in there. I will give you some examples in cases I've seen where the administrator or the conservator did not put the money in interest earning accounts. They go, well, they didn't have it. Well, it doesn't matter what they had. You're responsible for putting it in interest-bearing accounts. I have seen beneficiaries later come back and sue the administrator, sue the conservator, or sue the guardian, stating that they lost money because you did not put it in an interest-bearing account, and they want you to personally reimburse them for the interest they lost. Now, if you're talking about having cash accounts that have $100,000, and that's not unusual, or cash accounts that have a lot of money, and that interest that you could have earned each month can be significant. And if you're personally responsible for reimbursing the estate the interest that was lost because you didn't put an interest-bearing account, that could be significant to you, and you don't want that. So even if you opened an account already, you have not had it in an interest-bearing account, this would be a clue to you to go right away to that bank and say, hey, I need to switch this to an interest-bearing account, and go forward. You can't do, there's nothing you can do from about what you've already done in the past, right? So just correct it going forward. But it's important, and you do sign duties when you're appointed that state you will keep all funds in an interest-bearing account. So all I'm stating here is that I maintained all the money in an interest-bearing account. Statement of liabilities. If there are any liabilities, any liens on the property, anything like that, I would indicate it. But I also, if there are none, meaning a lot of times you can state in here if there's a reverse mortgage, if you know there's a mortgage on the estate, if you know that, say, property taxes, there's been a lien filed, you would hopefully get that all corrected and they don't file a lien, but I would state that there's many things I state if there are liabilities. This becomes really complicated when you're doing accountings for multi-property, like decedents who owned 4 or 5 rental properties or apartments or condos or Airbnb, things of that nature, where you have many different things coming and going within there. I state liabilities, for instance. I'll state if I have renters, I include as liabilities their security deposit. That's a liability. It's not your money. It has to be returned to the renter once they leave. So I'll state that. I mean, there's several little things I'll do in more complicated accountings.
If there's no property, would you leave that, or would you just remove that whole section?
I probably would remove the whole section if I only had cash.
Okay.
But be careful about how many sections you remove, because some of the things you have to have there, whether you have it or not. Other things, it doesn't matter. That is one, if you do not have any properties or liabilities, don't worry about the including it in. Number 7, sale of automobile. This is one that can be in there, but doesn't need to be. What if you didn't sell an automobile? What if they didn't have an automobile? Then, of course, you would not include this in here, right? Because if you didn't have it, you don't ask for the court to approve it. Again, this shows the sale of the automobile. So in this case, the conservator sold the conservative's automobile. It references it was included on the inventory and appraisal attachment 2. I usually don't say what line item, and in this case they sold it for a loss. 9 times out of 10 when they sell automobiles, it will be for a loss, because what you think it's worth and what you can sell it for can be completely different. You're also indicating that you've noted the loss on the Schedule D of your accounting, and you're requesting that the court approve that sale of that lost vehicle. What is the importance of that, or why do you think it's important to state that? So say, for instance, you, excuse me, sell the automobile and you have a loss. And later on, and you didn't ask, the reason why you're asking the court to approve it is that stops your liability. So say, for instance, beneficiaries, this conservator passes away, or when they do, and the beneficiaries go, I didn't agree or say it was okay that they lost $3,000 on a vehicle or whatever. If the court approves it, and you've indicated in here, and the court approves your loss, no beneficiary can hold you responsible. It's too late. The court approved it. It's done deal. So that's why a lot of times you may want to indicate something like that. But before even doing a sale what I always do is what's called a notice of proposed action, whereas I indicate that I'm selling the vehicle. You should give everybody who is entitled to notice at least 15 days. I'll say, hey, I'm selling this vehicle in 15 days. I'm selling it for this. It's going to be cash, blah, blah, blah. And if you don't like it, don't agree to it, don't want me to do it, you have an opportunity to object, but you only have 15 days to object. And then after 15 days, it's going to be done. And when you turn that into the court, it doesn't matter if a beneficiary agrees to it later or gets mad later that you sold it for a loss. You gave them the opportunity to object with a notice of proposed action. So they lose their right later kind of to object or contest it. So that's always something that I will do, or state people who are conservators to do, because that helps limit liability on a loss. Sale of furniture. Say you don't, in this case, I know the sample shows the vacation home. So selling the furniture or selling the vacation home, please realize that as a conservator, you are not allowed to sell the conservatee's real property unless you have court approval. Absolutely cannot do it. Especially if it's the conservatee's residence. Before you can even contact a real estate person to sell the home, you must get court approval, meaning you fill out a judicial counsel form that requests the sale of the property. You tell the court who the realtor is going to be, how much that realtor's commission is, blah, 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 blah. You go on. And the court will hold some type of hearing and then will approve and say, yes, you can sell the conservatee's home, or no, you cannot. They are very, very conscious that they don't allow you to sell the conservatee's home if they think for any reason whatsoever that conservatee either can go live at that home, can go back to that home, or anything of that nature. They will not allow you to sell it. Now, a lot of times I will add in, when I want to sell something of the conservatee's home, that squatters are getting in, or that homeowners and upkeep of the property, when I'm positive that this conservatee will never be able to go home. It's the expense. All you're doing is liquidating the conservatee's cash by keeping this house. But then the court has to go through, well, does that conservatee have a trust that the trust says that this house should go to these people? Is it a family home that beneficiaries have grown up? I mean, they take so much into consideration, and they're very leery about selling the conservator's home. Make sure you get approval first. So anyway, in this case, it was a vacation home, sold furniture. So I'm indicating here what happened, what I did, what I sold, how I sold it, whether I did a yard sale. You'll see at the bottom a garage sale and an estate sale. You always try and get the most money. You are not allowed, say your best friend comes in and says, hey, I'll give you $20 for that brand new sofa and love seat because I need one. You're not allowed to say, okay, that's a great deal, or anything of that nature, because that's your friend. Like, if you know that that brand new sofa and love seat can sell for $500 or $1,000 or more, then you must get the most for the property. If somebody wants to buy it, that's your friend. You can say, hey, let me figure out what the real value of it is. And if you wish to pay what the value of it is, sure, I'd be happy to sell it to you. So just make sure you're selling it for what any other person would buy it for. Don't just because it's your friend try to sell it for less, because that will get you in a whole lot of trouble. But in this case, they had an estate sale. They show what it's valued on the inventory and appraisal. They say there was a dealer commission of 20%, so they had to pay that. And they just indicate, sorry, I'm moving on, whatever happened within the sale. Okay, this is sale of real property. Again, the vacation home was sold, indicate that here. If there is not a sale of real property, don't include this. Now we're going to get down to, and I forgot who asked, but I remember somebody did, about the additional bond. Julie, maybe it was Julie. Yeah, I think it was. Anyway, about the additional bond, here we are. In the petition, we're saying, so in this case, now the bond really didn't cover a home because it's difficult to sell and it's not cash. So the bond originally did not include the home. Now the home was sold and now there's more cash. So what the indication here is, hey, I realized that originally my bond, say 50, 500, and now I sold this house and gained 183. So, or the total came to 183. So now I should indicate my bond to be all of my cash amount. So indicate, I feel that in this case or sample, this person went ahead of time and said, hey, I'm not even going to wait for a court order. I just went and told my bond company, can you increase my bond to the amount of my cash, and file the new bond amount with the court. But 9 times out of 10, it doesn't happen that way. I wouldn't say additional bond. I'd just say bond and say, the bond initially ordered by the court was 20,000. I now sold a house. The bond should be increased to this amount, blah, 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 and that would make it sufficient. This right in here just gives you samples and information when completing the form. Now I'm halfway through the form. It's probably a good time to stop. Does anybody have any questions on what I've discussed so far?
No.
Okay, you guys are quiet on me. Sorry, I was taking a drink and couldn't swallow fast enough. Okay, the next line item, no affiliated relationships. It's very important that this is always included on every petition you submit to the court for approval. What you are stating here is that you did or did not hire a family member or anybody of relationship to you or the conservator. Okay, so why is that important? A lot of people ask, okay, who cares? Let me use the example, same one I always use. I'm a conservator, and the conservator has a home in like a homeowners association or even not. But the conservator, before I took over, had a gardener. So once a week, gardener comes, and typically she paid, the conservatee paid, let's say $100 a month for a simple gardening. The gardener comes or contacts me and says, hey, just wanted to let you know for the month of November that I am going to be out of the country, or I'm going on vacation, or I need to leave because I have family members, there's a funeral, whatever the case may be. So I cannot mow the lawn. You at that point have 2 options. If it's in a homeowners association and you skip a week, who cares? Skipping 2 weeks the lawn might start looking a little raggedy, you might get noticed. So, okay. And or if they live on their own, you don't want the property to ever look like it's abandoned or the property, nobody's there or nobody's keeping upkeep on it, right? So I need to go look for a gardener because I'm the conservator. I'm going, oh, great. And it just so happens my son comes home from college and during this time and he's available and I say, hey son, I need you to do me a favor. I need somebody to go over weed eat and mow the lawn, blah blah blah. And he goes, okay, I'll do it for the month, but you need to pay me, I want $200. I'm going to ask you guys a question. What do you think about that scenario? Do you think I'm proper to say, okay, I'll pay you that 200?
No,
Or
no.
you are correct in that answer. Because he's a family member and because he's my son, I am not allowed to pay him, even if he was my last hope, anything more than I would pay any other regular gardener.
It would,
Now, what should happen is, say this gardener that I have that only charges $100 has been doing it for years and years and years, and he just gives my conservative a break, right? He gives just because he likes her. And I have to hire another gardener, and they say my rate is 150, and I don't go any lower. I call 5, 6, 7 other gardeners, and they all state their rate is 150. Well, it's okay for me for that time period to pay the 150 because I'm not enhancing my family member with the conservatives money. I just have to get the job done, right? Regardless. So I have to pay out the more money to the other gardener because I can't let the property just sit and not have gardening. So again, if I hired my son and paid my son any money, I'd have to indicate that. Another place
and
where
wouldn't you just pay him at the going rate anyway?
not if he didn't accept the going rate.
Well, then he wouldn't be hired.
Exactly, right? Exactly. Then I would move on. You're correct
But you
there.
could, he did accept it, right?
If he did accept it, the only thing is I would pay him, I would hire him, and I would state on here that the landscaping for the month of November 2024, my son did the landscaping, but he was paid the same amount as the gardener who he replaced for that time period.
Right. You just got to include it in that.
Correct.
Yeah.
The other reason why you would have a family member could be, which I did that one also, was the administrator of an estate. His wife was a real estate agent, so she was the one that actually sold the home. It's okay that his wife sold the home, perfectly acceptable, but I have to state it was his wife, and I have to state that I didn't pay her a commission, or he didn't pay her a commission, anything higher than what he would any other real estate agent. So as long as you're stating that and being upfront, you're perfectly fine.
So like I would state right there that because my kids helped me clean out my mom's house.
Correct.
And she was close to a hoarder. Well, she lived there since
many are. Don't be embarrassed. Many are.
So I could actually have them help me. They helped me clean up the house, so I could pay them, but I would just include it there and give them like the going rate of what I would if I hired somebody else.
Right? That's correct. And in my statement here on number 11, I would state my 2 children helped clean out the house. They worked 10 hours each at $20 an hour, or whatever the rate.
I wrote on the calendar each weekend we went there and they helped me.
Right. So that's perfectly acceptable, meaning you told the court, you realize it, you didn't It'd be different if you paid them 100 an hour and everybody else you'd pay 20. Yeah, that's a problem, but
Right.
not if it's just regular stuff. Yes, you just
Okay, thank you.
need to indicate. Now, say you did not hire anybody, you still need to tell the court you did not hire anybody of a family relationship. So this is not something that maybe you'll have on your petition. It's something you will always have on your petition. So it's not
Like a disclosure kind of, right?
correct. Absolutely. Okay, the next one is conservators' compensation. Now, many times a conservator, when it says conservators' compensation, a conservator who is a family member may decide not to charge his mother a conservatorship fee, or I have them where realize when you're paid a conservatorship compensation, that is a taxable item, meaning if you are paid an amount by a conservatorship, you must claim that income on your taxes. And a lot of times, the conservators or the guardians say, well, why would I do that? No, I'm not one, I don't want to charge my child or my mother or my aunt or, and the other time is I don't want to pay tax, so I'm not even going to charge anything. I'm just going to do this out of the kindness of my heart. That's your decision and your decision alone. If you wish to charge, you should not feel bad about charging because it's a whole lot of work. Trust me. I know it. I've, experienced it. It's a lot of work. So whether you charge or not is your decision and your decision alone. Do not let anybody in the family tell you, well, how dare you? That's you know what? It's not your business. It's mine. Thank you. And close at that. But you must state how many hours you put in. You must state what the relationship to the conservatee is. In this case, I like to indicate what did you do during that time so people can't question, well, I visited the care facility at least once a week. I made sure she was properly cared for. All her personal needs were met. She was showered properly. Her clothes were laundered. She was changed. She had no bed sores. She, had clean socks. Her hair combed, things of that nature. That's all part of the responsibility of a conservator. For a guardianship, I would say stuff like, I made sure they got to school. I helped them with homework, packed their lunch, took them to extracurricular activities. All this stuff that you do typically as a mom or a guardian. Maybe you're an aunt guardian. Maybe it doesn't matter. Anything and everything I did, not every little tiny thing. I'm going to lump it what I did. In this case, this person paid all the conservator's bills promptly, managed the estate frugally. What does that mean? Kept my money in interest-bearing accounts, made sure the bank wasn't charging me bank fees when I shouldn't have been, make sure I'm getting interest, make sure the account wasn't hacked and I got scammed. Make sure, so many things. That's all in works within this comment. So you arranged for the sale of the automobile because she couldn't drive it anymore. You listed the property. You met with a realtor. You had to sign all the papers. You had to review offers. You had to, I could go on and on and on and on. I don't know that I'd state all that and create a whole page of what I did, but kind of give an idea. Wow, you did spend a lot of time. Now, the conservator is only requesting $500 for his 150 hours. That's very nice because the going rate, and you must look at your local court rules for whatever court you're filing in. But I can tell you for Contra Costa, the non-professional fiduciary, which would be what a pro per would be, or anyone who has not passed the professional fiduciary license, things of that nature, the standard going rate for a conservator is $75 an hour. So you can charge up to that amount. It used to be 50 an hour. I tend to like to go and have my conservator really only get 50 an hour. I mean, I like to keep that conservative approach. I think that still 50 an hour is fair. But that's me personally. But again, I can't tell my clients who are pro pers what number to use. I just suggest how it looks, especially if this is your mother. You know, you're not trying to bankrupt mom. She needs that money to live the rest of her life. Otherwise, what's going to happen if you bankrupt mom? You're going to end up having to care for her and pay for her expenses out of your own pocket and never get reimbursed if she has no more money. So don't try and take it all from her, right? But use your discretion. You decide, maybe I don't want to charge the 50 an hour. I only want to charge this amount. I think it's fair. Well, great. Then do what you feel comfortable and you want to do. Again, the court has to approve this anyway. So if the court doesn't feel it's fair, you're not getting it anyway. So if you charged 100 an hour, the court's going to go, yeah, that's not working. No, you're not getting it. So they watch for that also. But that's this section. Is there any questions about compensation, whether you're a conservator, a guardian, because this does not work for probate cases. Probate cases is a statutory fee based on assets. So your administrator fee, executor fee, whatever, cannot be done this way. It's a totally different working that you do, totally different. So this again only pertains to conservators or guardians. Is there anyone who has questions about this compensation section? Or
if you're not looking for compensation, can you just omit that whole section?
no, hun.
No.
You must state conservator compensation. What I typically do when I write these up would be conservator has spent all these hours. This is what the conservator has done in the case. Conservator waives compensation.
Okay, thanks.
Or guardian waives compensation. That's what I do. I still list, maybe not how many hours, but I still list what I did and how much, I properly cared for the person, blah, blah, blah. I just don't want compensation at the end.
Makes sense. And then what about attorney? If you don't have an attorney, can you omit
Again,
that?
we're going to go down that.
Oh,
That's
okay.
correct. Even if you did not hire an attorney, you're pro per, I indicate attorney's compensation and I type conservator did not retain the services of an attorney, no attorney compensation requested.
Thanks.
That tells the court you didn't skip it, you didn't miss it, there's no question about, well, did they hire an attorney and they're forgetting to ask for compensation? It's very clear in here, I didn't hire one and I'm not asking for one to be compensated. Right? Again, paper standing on your own. The court should never really have to question anything. You're telling them everything within this petition. So I can read this and go, okay, Oh, they hired an attorney even though they're pro per. What did that attorney do? Did that attorney help just review the real estate stuff? Did that attorney, like, they have to be very specific, and you'll have a hard time finding an attorney to assist if your conservatorship is of a lower value, because they know they wouldn't get reimbursement for their time fully. But anyway, always include this statement whether you hired one or not. You will just indicate whether you want them to be compensated or not. So, and then again, for a probate case, this is completely different, because a probate case, the attorney's compensation is also statutory. So it has a completely different petition look than this one right here, because it has to show how you computed the statutory compensation, etc. Okay, moving down to veterans benefits. I see many of these that I review that the proper doesn't add this in because they don't think it's necessary. It's very necessary in every single petition, even a probate petition. When you state whether the conservatee, the minor, or the decedent received any veteran benefits. If they did not, you state they did not. If they do, you state they do. Like, say for instance, the conservator's real property was bought with a VA loan. Maybe the VA assisted with some of the down payment. Maybe, and would be important if you knew whether the VA was requesting at the death or, the sale of the home, whether they're entitled to some type of reimbursement back or something of that nature. But always include this. State hospital, very important that you always include this also. Even if the conservatee was not ever in a state hospital, or the minor was not in a state hospital, you need to state such. So you'll state whether they were or they were not. Ooh, I'm going over my time. I'm sorry. We're almost done if people want to hang in there. Conservatee's address. This would be minor's address. I typically don't like doing this because this is public information. I don't want people to know where this conservatee is. For everybody who needs to know where the conservatee is, they've already been told that through other documents. So typically I put the conservatee still resides at the same residence they did when I filed a petition, or conservatee's address has not changed, something of that nature, but I do always indicate something. Minors, if minors, say for instance, minors go live with grandparents or something like that, it's not a temporary move. It would more be permanent that you would have to state. Okay, account statements. Account statements. You are responsible for turning in the original copy of every single bank statement. I am being very much stressing the importance of original. If you have a probate case, a conservatorship case, or a guardianship case, very important when you open up the bank accounts that you tell the bank you must receive mailed copies of the bank statement. That doesn't include online access. Or if you choose to do online access and your statements are delivered via online PDF, what you have to do when you turn in an accounting is you have to go to that bank, you have to have them reprint every single bank statement, and they have to certify it as such. They have to indicate somewhere on those bank statements that they at the bank printed those bank statements. The purpose for that, a PDF or something you download online, I can tell you on a PDF or any PDF, I can manipulate the heck out of that PDF, and I can guarantee you, you'll never be able to know what I changed, right? So I'm very, the court has to be very careful that somebody hasn't changed the information on the PDF itself, and therefore they request it either being the original copy or copy from the bank. Just note that a lot of times, a lot of the banks, if you ask them to reprint statements, they will charge you a fee to reprint those statements. Typically, those fees are paid for by the conservatee, but if they get to be ridiculous, which I've seen some, the courts don't like it, and they'll say, yeah, no, you're going to pay these fees. It's your fault you didn't get paper statements. But I will tell you, that's changed a little bit in the fact that now all the accounts are e-filed, or typically they are e-filed. So with e-filing, people ask me, well, how does the court know whether it's the original or not? When you ask that kind of question, it's kind of scary, because just submit originals and don't ask any questions like that, because they may change. So it's nice they allow us to e-file them. When submitting your account statements, you cannot ever attach them to this petition. There is a separate cover page. I think Rex included, I see it right now in the sample. Here is a separate cover page. Again, you put your data, your court, your case number, you state original bank statements. I don't use these words. I say original bank statements for Wells Fargo Bank, March 8th, 2012 through March 7th, 2013. Never put a hearing date or time on it. And then original bank statements and a footer. The purpose being is, and I do more than that, I will put confidential original bank statements. Your bank statements that you submit to the court will be confidential, meaning they can never be accessed online or by anybody except for you or some judicial officer. So they're kept private. And that has to do with, scamming or somebody else getting too much information. So do not ever, if you submit them with your petition, the court just screams and hollers. They are very upset with you. Do not ever do that. They must be submitted separately and filed with the court. Any questions on that?
So that you want to do in person, obviously. I mean,
Well,
filing in person.
Or you can mail, hun.
Oh, okay.
Yes. But I e-file them also. I've done that for many people, where I still include a cover page. I'll e-file it. And when you do an e-filing, if you've done e-files a lot, there is a do a pull down that says confidential.
Oh, okay.
And it marks it as a confidential document, meaning no one else can access it. Okay, but you'd still tell them you've submitted to the court your bank statements. You still include this statement. Changes, again, if there are any changes, capital changes really mean for stock accounts where you've sold stock or purchased different stock, or maybe you noticed you have stock in what is it? Trump's True Social that's tanking, from what I hear. So then you go, oh no, that needs to be sold right away. You state you do that. But whether or not, you would just state no changes. if you have that type of an account. Okay, estimate of liabilities. In this case, I'm indicating to the court that the main home owned by the conservatee has a mortgage on it, whether, again, where I stated the reverse mortgage, blah, 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 you state the information. Sometimes it's a little bit difficult to get what is the interest rate. I don't know that I always put that, because sometimes I can't get it, or it's too difficult to get it. So I am able to see, because I do run deeds, I'm able to see when the bank put the promissory note or whatever on the home, what the balance should be, and I'll indicate that. On
And
number
again, with no property, would you indicate there's no property in this estate, or would you just remove that?
You would state, hun, under your statement of liabilities, there are no liabilities in this account.
Okay.
Or for this account, or the minor does not have any liabilities.
So when you're filing your inventory and appraisal at the court after you get it back from the referee, do you have to put all the attachment things on it for your attachment of your scheduled, all those? Because does that always go together? Your accounting, like itemizations?
Okay, honey, sweetheart, you're talking two different things. Inventory and appraisal will only attach attachment 1 and attachment 2. You will see when I get done, I'm almost done, 3 more pages, how you will attach your accounting and all your schedules. I'm not there yet.
Okay.
Sorry.
No, I just was wondering when you go to the court after you sign it and it comes back from the referee, if you have to attach your other
No, you keep that. It doesn't, you just keep the copy.
Okay, thank you.
You keep the copy so that later you do your accounting, because they're not typically done at the same time. Your inventory and appraisal is done way early.
Right,
and then
because
your accounting.
Yeah, it's
right.
kind of premature.
Right. So you need your inventory and appraisal to start your accounting, but you never do anything else with that inventory and appraisal.
Okay, thank you.
Okay. So request for special notice. You must have this on all documents. You will know if somebody has filed a request for special notice. And what does that mean? I myself can go to the court and pay $40, and I can file a request for special notice on any case whatsoever. Any case. I don't have to be related. I don't have to know you. I don't have nothing. I don't have to do nothing. I file this $40 request for special notice, and every single time you file a piece of paper with the court, you have to send me a copy. This is done often. It's usually done by people who take inheritance advances on probates. It's done by family members who, let's say, you have a minor and possibly, aunt passes away and all her kids want to make sure that you're managing the child's money properly. They may ask for special notice. Any reason, you must state whether a request for special notice has been filed or has not been filed. If somebody does file a request for special notice, the court does force them to deliver a copy to you. Once you get that copy going forward, you must always know you have to include them on the service list. But you do need to indicate on your petition that there is or is not a request for special notice. Okay, now we're getting down to the prayer. So now I told the court everything court needs to know. I'm done. Okay, I'm finally done, right? Now I'm getting down to what's called the prayer. I don't enter mine this way. I typically in the center of the page will say prayer, and then I state wherefore the conservator prays. Whether you're religious or not, the praying doesn't mean the same thing as a Catholic prayer. You're not getting on your knees. You're not begging. You're not anything. It's just a respectful way to tell the court, please do this, right? And this is what you're asking the court to do. Okay, right? So I told a story up above. Now I'm telling the court what I wish them to do. I wish them to approve and settle this account, right? I wish them to approve all the acts that I've done during this account period. So those two are typically common on every petition. Number 3, selling the automobile. If you didn't sell the automobile, you're not asking the court to approve it, right? So number 3 would be optional. Number 4 would be optional. Remember up top, I talked about auto and I talked about furniture. Number 5, important, whether you're paying yourself or not. Number 5 asks for the conservator to pay himself, herself. What sum did you ask for compensation? Now I'm going to go back. I think, Julie, I think it's you. I keep forgetting. You're on the guardian case, right?
No, I'm on
It's
the
me, the minor. I have the minor.
Okay, sorry.
I'm not trying to give myself any money.
Right. So you still will want to indicate that upon a settlement, conservator does not request or is waiving compensation.
Okay,
so
thanks.
you still indicate that here, hun.
Thanks.
Or the guardian is waiving
Yeah.
compensation. So whether you are or not, you'll put that in. Then again, no attorney. I do not indicate this down here that I wish the attorney to be paid because no, I didn't have one. This is not an and or in this case. If you did not hire an attorney, don't put this in. Then I'm okay. So also say for instance, and I'm going to go back to Robin, you needed to be, and I'm sorry. So up top where I have the, up top where I stated conservatorship fees. Sorry, I need to find it. What page is it on? Here. Conservator compensation. Say you have expenses or the guardian has expenses that they paid prior to getting a hold of any money or prior to having any money to spend, or maybe the money is in a blocked account. And you have expenses you want to be reimbursed. You would add right below the compensation, you would add as 13 conservators reimbursement or expense reimbursement. And you would state, I, as the conservator, prepaid these expenses and I request that the court please allow me to reimburse myself. And then you would put that in a paragraph just like this. Do not skip it, so that when you got down to your prayer, you would also, after you ask for your compensation, you would ask for reimbursement. Now, the one with the guardianship, let's say, for instance, the minor had braces, and maybe it was a father who was always paying the monthly fee for the braces. Father, let's say, passed away. And so while you waited for his estate to get money to the minor, you paid for the child's braces, right? The payments for the braces. You could ask the child to reimburse you those expenses you prepaid and get reimbursement back. You're not taking from the minor in that case. They wouldn't have got it if dad was still alive and paying for the braces, right? So it's not like you're taking from your child. Don't look at it that way. You're just reimbursing yourself for something dad was supposed to take care of anyway. So you would include, after asking for compensation here, instead of attorney payment, you would say reimbursement of expenses paid in whatever amount it is. And Robin, this is where I'm stating, without the judge approving these two line items, or even if you say no compensation, but you want reimbursement of expenses, you do not pay yourself till the judge signs off on it right from this ask request.
Okay. Okay, thank you.
And then I always state that the court can grant any other thing they wish to, right? Because if the court wants to do something, I'm not stopping you. Go for it, right? Who am I? So I always put in grant any other relief that's proper and sign. Okay, we're at the very end. So now I've told the court actually what I want the court to do. I date it. I sign as the conservator, delete the line about the attorney, because if there is an attorney, we all know attorney signs first, conservator never signed right here. So this is wrong. So delete, do not include that part. But what thing that's very important, and I see on a lot of probate notes, is a verification. So the next page is the verification. You must state under penalty of perjury that you know what you're submitting, you understand what you're submitting, you believe what you are submitting is truthful and honest to the best of your belief. And you have included everything that needs to be included. Basically, you can just copy this. I typically say my first account, or I repeat what my caption was here. I repeat it on the verification starting on this line item, and then say which includes reports and schedules and blah, blah, blah. And then under penalty of perjury, state of California, date it, sign it as the conservator, and then which is not in the sample, you need a blank page. So I continue this on. I will skip and make blank all the way down to about line 25, 24, 25, right about in there. And I will create a page that's called Exhibit 1, right? I type the words Exhibit 1 or Exhibit A, dependent which do I want to use letters or numbers, right? And then that page, that's all that's on that page. And then I attach the accounting that I completed behind that Exhibit 1, and I submit this as one document. It could be 50 pages, it could be 30 pages, it could be, some of mine are 100 or more pages, but it's one document. Do not try and submit your accounting as a separate document by itself. One, the court won't take it. Two, the court doesn't know what to do with it because you haven't include captions and case numbers, and they cannot accept documents that way. You have to include it as an attachment to this petition. Now, this is the end, and I want to state a few more things for people who want to stay on because it's not in here. This is only the petition. What is not part of the class in our training is the order that also must follow. You've only asked the court to approve something. You've signed it. There's no place on here for a judge to sign. That's because an order has to follow. When you complete an order, instead of this caption, you're going to say order regarding, and then I just repeat this. Again, leave the date of the hearing and blah, blah, blah blank, and you will almost duplicate what you've said here in some ways. You don't need, I include the appointment on my order. I don't include the inventory and appraisal, but so you could look up, but your order then tells the judge that I've already prayed in my petition for this, and I'm almost repeating what my prayer is on the order. So I'll say that this account is approved and settled. that the acts of the conservator are approved, that the sale of the automobile is approved, that the sale of the furniture is approved, that the conservator is authorized to pay himself or herself the sum of $500. Then I end it. The conservator is authorized and directed to pay himself or herself $50 for expense reimbursements, and any other order the court grants. And then the date, I leave blank for the judge to date it. And then I sometimes include the judge's name if I know it. If I don't, I'd leave that blank and I'll put a comma and say judge. And then they sign it, put their name here, and that's how you get returned back to you. Now, I also must say, in Rex's materials, he only lists contact information for himself. So I want to include information on how to contact me if you had any questions, if you cannot balance, if you just get stuck, if you can't remember, if something just seems crazy and you just can't figure it out. I do offer, you are allowed to contact me via email and send your request to me. If it only requires 20 minutes, 30 minutes for me to quickly go, okay, I get it. I see where you're wrong. I see how you can't balance. I will quickly do that free of charge. If it takes longer than that, a lot of times I'll say, it might be best you just let me do this, or, you let me start over, or I would have to start billing you for my time, things of that nature. But I say that, and most of the time I help people and never bill them anyway. But I want to give you my contact information. So if you have a pen and paper, my email address is California, CA, the word legal, LEGAL, docs, DOCS, the number 2 at Gmail. And I'll repeat it. CALEGAL, docs, DOCS, 2 at gmail.com. You can send me a message and go, Tamara, I need help. What am I thinking here? Where have I gone wrong? Do I need this? Anything of that nature. I usually answer that day. If not that day, it'll be the next day. You just have to tell me a little bit. Don't say, remember, I was in one of your classes, because we do this so often, I will not remember. And just give me a little bit. I have a guardianship. I can't get this to balance, or something of that nature. And then typically I'm able to say, hey, go look here, or maybe your inventory started off wrong, or, something like that. You're able to contact me and I will assist you as best I can. But understand, I cannot give you legal advice. I can only talk about the accounting itself. And if it has to do with a petition we've presented here, I can help with that. But if it was, I think this stock is losing a lot of money, should I sell it and buy new stock? I cannot give you that type of answer. That cannot come from me. I'm not an attorney, and I just cannot help you with that type of case or analysis. But if it has to do with the accounting, I can. So I've completed. Is there anything that you can think of? I'm sorry it went over. Is there anything you can think of before we close that I haven't covered and you had a question on?
I have a very specific question, but I will let other people chime in first.
Okay. Anybody else? Thank you all. I hope it was helpful. I know people from the law firm, this was kind of, a little bit different.